Mr. Chairman, I'll let you know as soon as that connects over to YouTube.
Perfect. Thank you.
Mr. Chairman, it looks like we are live.
Thank you very much. Looks like we're live on YouTube. This is the Senate Joint Senate Corporations Elections and Political Subdivisions Committee. Mary Beth, could we do roll call, please?
I'll be doing the roll call for you, Chairman Driscoll.
Thank you, Danielle.
Senator Boner,
Here.
Senator Case,
Present.
Senator Nethercott,
Here.
Oh, she is here. Thank you.
Senator Scott,
Here.
Chairman Driscoll. Mr. Chairman, you have a quorum.
Perfect. For everyone out there, we've got 4 hours and a hard stop on it. We've got 3 bills that we're going to for sure get through, so it's going to be a pretty timely manner. I ask that everybody follow decorum and listen closely to what direction we have. We're taking up at least one bill that's going to be fairly time consuming and pretty passionate. The first bill we'll bring up is Senate File 14, credit for reinsurance. Anybody that would like to testify as we come to the public end, we ask that you enter the room and raise your hands, and you testify in the order your hands are raised. Mr. Rude, are you available or have someone available to present the bill for us this morning? I am not in a mode to be able to turn him on and off. I don't know.
It would be Jeff Rude.
I see him on the list, but I went through the training yesterday.
I see him here.
I cannot, nothing pops up. Am I in the wrong screen on this?
Mr. Chairman, I have 2 boxes with Jeff Rude on it on my 6 or 3x3 panel. So he needs to unmute. And one of them's got his hand raised.
Okay. Danielle, am I on the wrong screen somehow? I'm not showing anybody's boxes.
Mr. Chairman, can you hear me now?
Yes, sir.
Sorry about that. I think we're okay now. Let us know if the volume needs adjusting or anything. Mr. Chairman, my name is Jeff Rude. I'm the Commissioner for the Department of Insurance. With me today is the Deputy Commissioner, Ms. Johnson. Before you is a amendment for credit for reinsurance bill, and Ms. Johnson will walk us through that.
Welcome, Ms. Johnson.
Okay. Excuse me. Thank you, Mr. Chairman. My name is Linda Johnson. I'm the Deputy Commissioner with the Wyoming Insurance Department. And the bill you have in front of you is Senate File 14. And this bill updates Chapter 5 of the Insurance Code, which relates to credit for reinsurance. And this is a law that we've had on the books for a long time. And we last updated it in 2017. And now we're requesting that it be updated again due to international developments and also in order to avoid federal preemption. In addition, it's also a National Association of Insurance Commissioners accreditation standard that the department will need to have in order to maintain our accreditation with the NEIC that we've held since 1993. If I could, before I get into the bill, if I could just go through a little background about the purpose of the bill and how it came about, and then I can start going through the bill after that. Will that be acceptable?
That would be perfect. Thank you, ma'am.
Okay. So as a little background, I wanted to explain what reinsurance is. Basically, reinsurance is insurance for insurance companies, and you and I as policyholders don't deal with reinsurance. This is something that happens in the background without our knowledge, but it's basically an insurance company passing off some of its risk to another company called a reinsurer or an assuming insurer. So it allows an insurance company to reduce the liabilities it reports on its balance sheet because it's ceding off some of its risk to a reinsurer or multiple reinsurers, provided those reinsurers meet certain requirements. So the reinsurance, excuse me, The reinsurance framework that we currently have in Chapter 5 provides 6 different ways that a domestic insurance company can reduce the liabilities it reports on its balance sheet by using reinsurance. So this bill, we're adding a 7th way that a domestic insurer can qualify to reduce its liabilities by using reinsurance, provided those reinsurers meet certain requirements. And in the past, we used to require offshore reinsurers to post 100% collateral for any risks that they assumed from U.S. insurance companies. And this became an international trade issue because a lot of the world's largest reinsurers are across the Atlantic. So like your Lloyd's of London, Swiss Re, Munich Re, those types of companies. So back in January and February of 2017, you may recall that we updated our law to allow these offshore reinsurers to be able to reduce the collateral that they hold for U.S. risks based on whether or not they were a certified reinsurer that was domiciled in a qualified jurisdiction. So therefore, it gave these offshore reinsurers an avenue to be able to reduce the collateral that they held for U.S. risks. So instead of holding 100%, maybe they were only required to hold 10% or 20% based on their financial stability and whether or not they were domiciled in a qualified jurisdiction. So fast forward to September 2017, and this is when the U.S. Trade Representative signed a covered agreement with the European Union, which eliminated all collateral requirements for EU companies, provided they met certain requirements. And then in December of 2018, the U.S. Trade Representative signed a similar agreement with the UK, which mirrors the EU agreement. So based on these agreements, state insurance regulators have 5 years from the date the covered agreement was signed with the EU in order to come into compliance, or else we face federal preemption. And so in summary, this bill, we're introducing the concept of reciprocal jurisdictions, which allows reinsurers in those jurisdictions to not have to post any collateral for any U.S. risks that they assume, provided they meet certain requirements. So I hope that provides a little bit of background about the whole international issue and federal preemption possibility. So with that, I'll go through the bill, and I know you have a lot of bills on your plate, so the first out, kind of hit the highlights. Is that or our interconnect able does?
Mr. Chairman, maybe while their connection gets a little better, I can give you some Linda Johnson trivia. Her father served as the Sergeant of Arms in this Wyoming Senate for a considerable amount of time, Art Lockman. So we were, I'm not sure how he's doing. I'm almost afraid to ask because he's quite elderly and in a nursing home in Cheyenne. But he served us very faithfully and was a wonderful person. And if you go to the UP Railroad and go to their collection of old train cars, one of them is called the Art Lockman. He's worked for the UP Railroad.
I have been down there and seen that, did not know the history on it. I thought my internet connection was bad. I'm glad to know it's theirs and not mine.
I see their screen is frozen. I'm not sure why.
Yeah, it froze on mine, and I thought it was my computer was doing it. So, do we have?
Mr. Chairman, what you might do if we're waiting for them to come back, there is testimony in the audience. I can see Ms. Wilkinson and others in the insurance agent industry that would probably talk, but I see they're back and they're moving. So, okay.
Very good. Welcome back.
You're muted.
Trying to find him.
All right, our apologies, Mr. Chairman. We had the flashing warning sign of disrupted connection, so we'll press on.
Perfect. Thank you very much.
I'm not sure where or what the last thing you heard was. Did you?
Starting right into the bill. We were just starting on page 1, basically.
Excellent.
Great. Okay. Sorry about that. So I'll go through the bill on page 1, section 1. We're adding a few new paragraphs here. So at the bottom of page 1 on line 14, we're updating section 112 of chapter 5 to include Roman numeral 7. Which is on page 2, line 20. And here's where we're adding that 7th way to allow a ceding insurer to take credit for reinsurance. So line 20 says, when the reinsurance is ceded to an assuming insurer, which is also a reinsurer, that has its head office or is domiciled in a reciprocal jurisdiction and is licensed in a reciprocal jurisdiction. So now we're on page 3 at the top. And we define reciprocal jurisdiction later in the bill on page 12, but basically these would be those jurisdictions like the EU and the UK that has a signed covered agreement with the United States. Excuse me. On line 5, it says the assuming insurer has and maintains minimum capital and surplus specified in rules adopted by the commissioner. We will have to update chapter 50 of our rules to adopt this legislation, provided the bill passes. But what that regulation would require is $250 million in capital and surplus for the assuming insurer. So these are your large companies. And then on line 18 of page 3, it says the assuming insurer has and maintains a minimum solvency or capital ratio as specified in rules adopted by the commissioner. And again, this would be a 300% risk-based capital ratio in accordance with chapter 8 of our insurance code, or it would be based on another country's capital ratio, provided they have a framework in place. So if you go over to page 4, on line 6, it says that the assuming insurer has to agree in writing to the following 5 requirements. And this will be specified in rules that, again, we'd need to adopt or update. On line 10, the first item that the assuming insurer has to agree to in writing is they shall provide prompt written notice to the commissioner if it falls below the minimum capitalization requirements or if any regulatory action is taken for serious noncompliance. And then the second item they need to agree to in writing is on line 17 of page 4. And this says that the assuming insurer shall consent in writing to the jurisdiction of the courts of this state and to the appointment of the commissioner as agent for service of process. And if you go over to page 5, line 6, the third item the assuming insurer has to agree to is that they shall consent in writing to pay all final judgments wherever enforcement is sought, obtained by a ceding insurer. And then, excuse me, the fourth item is on line 12. And this says that each reinsurance agreement shall require the assuming insurer to provide security equal to 100% of the assuming insurer's liabilities if the assuming insurer resists enforcement of a final judgment. And then the final item that they have to agree to in writing is on page 6, line 1. And this says that the assuming insurer shall confirm that it is not presently participating in any solvent scheme of arrangement which involves this state's ceding insurers. And solvent scheme of arrangement is a UK mechanism, and it's I've had to Google it because I wasn't familiar with it. It's, again, done in the UK, and it's not very beneficial to policyholders. So the protection in here is that we would require a reinsurer to post 100% collateral if they were participating in any of these solvent schemes of arrangement, and that would protect U.S. policyholders. On line 13 of page 6, it says the assuming insurer shall provide documentation to the commissioner as specified by rule. Excuse me. And on line 19, page 6, it says the assuming insurer shall maintain a practice of prompt payment of claims under its reinsurance agreements. And then if you go over to page 7, the assuming insurer's supervisory authority shall confirm to the commissioner on an annual basis that the assuming insurer complies with the capitalization requirements, which is on page 3 of this bill. And then on line 9, it says an assuming insurer can provide information on a voluntary basis as well, so nothing prohibits that. And then on line 13 of page 7, it says the commissioner shall timely create and publish a list of reciprocal jurisdictions. We currently do this on our website for the 2017 changes that we had. We have a list out there on our website of qualified jurisdictions. So we would need to add a list of reciprocal jurisdictions, provided this bill passes. And again, that's on our website. If you go over to page 8, line 14, the commissioner shall timely create and publish a list of assuming insurers that have satisfied all conditions and to which cessions shall be granted credit. And again, we already have a list of certified reinsurers on our website, so we would be able to maintain this list as well. And if you go over to page 9, on line 5, It says, if the commissioner determines that an assuming insurer no longer meets one or more of the requirements, the commissioner may revoke or suspend the eligibility of the assuming insurer as set forth in rules. So there is a remedy there if the reinsurer falls below the requirements. And then going over to page 10, line 4, if subject to rehabilitation, liquidation, or conservation, the ceding insurer may obtain an order requiring that the assuming insurer post security for all outstanding ceded liabilities. So again, another protection there. And then if we go down to line 19, on page 10, it says credit may be taken under this paragraph only for reinsurance agreements entered into, amended, or renewed on or after July 1, 2021, which is the proposed effective date of this bill. And that is providing that the assuming insurer has met all of the eligibility requirements. So this is just prospective, effective prospectively for any agreements that are entered into, amended, entered into, amended, or renewed on or after July 1 of 2021. So any current reinsurance agreements that are in effect that require those reinsurers to post a collateral, they would still have to post collateral until this bill would be effective. And then if you go over to page 11, I'm going to skip down to line 21, and we're adding some definitions here. So on line 21, we're defining covered agreement, which means an agreement entered into pursuant to the Dodd-Frank Act, and that addresses the elimination under specified conditions of collateral requirements. And now we're on page 12, line 8, we're defining reciprocal jurisdiction. And there are 3 ways to meet the definition of reciprocal jurisdiction. On line 11, you can be a non-United States jurisdiction that is subject to an in-force covered agreement with the United States. So that would be like the EU or the UK currently. And on line 17, it could be a United States jurisdiction that meets the requirements for accreditation. And then on line 21, it could be a qualified jurisdiction that meets certain additional requirements consistent with the covered agreement. So those are the 2, the definitions that we're adding. And then if you go over to page 13, line 6, this section 116 deals with our rules and regulations. And again, we'll need to update chapter 50 of our rules here. The paragraphs here are basically saying that if a company is a professional reinsurer, they don't have to meet the captive reinsurer requirements that have already been adopted. And that's kind of a whole different story, so I won't go into that, but there's just some language there to clarify which requirements apply to who. And then on page 13, on line 20, and then on page 14, line 2, we're just renumbering existing language there. And then on line 16 of page 14, we're saying this act is effective July 1 of 2021. Are there any questions?
You're muted, Mr. Chairman.
There you go, Senator Scott, go ahead.
Mr. Chairman, several questions on page 8 and 9, where you've got all those lists to keep updated. Am I right in thinking that the NAIC will support this, and that's where you're going to get your information?
Mr. Chairman?
Go ahead.
That is correct. With this process, the current process with certified reinsurers and qualified jurisdictions, we have not been the lead state on those reviews. So we are able to, they call it passporting. So if the NEIC in another lead state has taken a good look at these different jurisdictions and these reinsurers, then we can passport that application and we don't have to do the full review that has already been done. So we rely on other states for that expertise.
Follow up, Senator Scott.
Mr. Chairman, next question. On page 12, line 21, item C, that third way in there, what kind of jurisdictions are we talking about here? Is anybody using this? Is this something for Canada or something like that? What's going on here?
Mr. Chairman?
Go ahead.
So right now we have 7 qualified jurisdictions based on the law we passed in 2017. Those qualified jurisdictions are Bermuda, France, Germany, Ireland, Japan, Switzerland, and the UK.
Further questions, Senator Scott?
Mr. Chairman, a more general one. This is an NAIC accreditation bill, and we've had quite a number of these. If we're explaining this to the Senate, is it safe to say that the NAIC accreditation system has worked very well, and in the crash back in 07, 08, 09, we didn't lose any major insurers because of the way the NAIC system is working. We lost a holding company or two, but that was due to stuff that's not insurance and was regulated by the feds. But the NAIC system really stood the test of time, and it's something that works and we can count on. Is that a safe statement?
Mr. Chairman?
Ms. Johnson, go ahead.
Yes, I would say so. And I didn't go into the background of the NAIC accreditation program, and I know there are a couple new committee members, but the NAIC accreditation program came about in the late 80s, early 90s, because there are several large insurance company failures. And it was there was a report commissioned by Congressman Dingell at the time, and I think it was called Failed Promises. And it was basically pointing out some weaknesses in the state insurance regulatory system. And so in order to prevent the federal government from taking over the regulation of insurance, the states got together and developed the accreditation program. And so we have a lot of standards right now for how we examine our insurance companies and monitor their financial solvency, and also what we do about what happens if a company does go insolvent. So I think it has really, I mean, I wasn't here in the late 80s, early 90s, but I think it really has stepped up state regulation. And the whole point of that was to keep it in our hands instead of handing it over to the federal government.
Thank you. Senator Scott, further?
Mr. Chairman, that covers it. I would say that I was involved in the late 80s, early 90s when I was chairing Corporations Committee and on some of the early accreditation bills. And in those days, they were paying their lawyers by the pound, and they were very lengthy, and they've cured that disease in good part.
Thank you. Committee, further questions? Any questions? Very good. We will, I don't think we have anything else on the bill. We will go ahead and go to the public. If you'll raise your hands, we will admit you out of the waiting room. So whoever raised their hands will go from there. We'll have one to start with, and then we'll notice behind that. We're new to the system, everybody, so I'm not seeing anybody. I had heard, Ms. Erberkite, did you want to testify on this? Christian Lee has her hand up. I'm trying to find her on the list here. I do not. Okay. Go ahead, Ms. Lee. I cannot unmute her from here.
Mr. Chairman, I'm not sure if she's having some technical difficulties. I've asked her to start her camera.
Okay. Looks like she's trying. She's off mute. Can you hear us, Ms. Lee? Okay. Do we have anyone else that would like to testify while we're working with Miss Lee?
I'm looking down the list for you, Mr. Chairman. I don't see anybody else.
I don't either. That's
We do get a couple of folks from the industry that are kind of part of this insurance department's fan club, and they usually come forward. And I do see one now, Vincent Ryan.
okay. Thank you. Vincent Ryan is here, and I do not have a. He's in the room now, so I'm going to have to. There we go. Vincent, can you unmute? There we go.
Yes,
Welcome,
can you hear me?
Mr. Ryan.
Good morning, Mr. Chairman, members of the committee. Good to see everyone today. Commissioner Rood, good morning. Just wanted to make a statement of support on the record, appearing today on behalf of the American Council of Life Insurers, representing over 230 life insurers and reinsurers doing business in Wyoming. I wanted to thank Commissioner Rood and his staff for bringing the bill forward and for all of their work at the NAIC. Thank you, Mr. Chairman.
Very good. Any questions for Mr. Ryan? Any questions, Mr. Ryan? Thank you, Mr. Ryan. Looks like Christian Lee got where we can. Still not there.
Mr. Chairman, thank you, Mr. Chairman. I think Ms. Lee is representing the same industry as Mr. Ryan, who just testified in front of us for the life insurers. And they also provided written correspondence to the committee in support of this legislation. So perhaps if we're unable to get to Ms. Lee, we certainly appreciate hearing from them in their position, which has been provided to us both through Mr. Ryan and through her written correspondence.
Thank you very much, Senator Nethercott.
And Mr. Chairman,
Senator Case.
if I may just have one moment, I expect that in a normal year when things were great and he was still alive, Mr. Dave Buchner would come forward and he would support this bill. And that's pretty much enough for me.
Very good. Thank all of you committee members for having patience bringing me on board here. This is a new one for your chairman. So with that, I see no more hands. Public testimony is closed. Committee, what is your pleasure?
Move the bill.
Bill's been moved and seconded by Senator Boner. Discussion on the bill. Senator Boner.
Mr. Chair, more of a technical question, I guess, maybe for the commission. Since this is a bill dealing with a lot of moving parts, I'm just wondering, I don't anticipate any amendments or attempted amendments as it goes through the process, but just so we're sure, if we attempt to amend this bill, would that have the effect of nullifying its effectiveness since we're dealing with multinational jurisdictions? Just a question as we try to anticipate some forward discussion.
Ms. Johnson or Mr. Rood?
Mr. Chairman, that's a very good question. When this model was being developed, I know the other countries like the EU and the UK had a lot of say in the wording, and we were given instructions by the NAIC, a very strong encouragement to stick with the script, because if we do tweak something, we could face federal preemption if we don't stick with the language that has already been agreed to.
Well done, thank you. Further questions, Senator Boner? Very good.
Question on the bill?
Question being called on the bill. This will be
One thing before, Mr. Chairman,
Senator Case.
just by way of kind of pointing out to folks that may be listening. So in the United States, insurance regulation largely occurs at the state level. That's why we have these bills. And there's a lot of effort among the states to work together to have consistent laws across all the jurisdictions. And the reason for that is really we're all trying to avoid being federally preempted or have insurance move to be a federally regulated entity. And there are still some things that happen at the federal level with respect to it. But that's why we see these model laws that are, you'll see a lot of these in your tenure as chairman of the committee. And we usually find that there's very little we can do to depart from the concepts, although Senator Scott does explore a lot of areas and he does pretty well. And sometimes we get away with a few things. But in general, the reason we spend so much time on this and the Department of Insurance spends so much time on this is we, as one of the 50 states, are trying to avoid a federal preemption in the insurance markets.
Thank you very much. Let's go ahead and go to roll call. I don't know if it's Danielle or Mary Beth's going to call for a vote.
Mr. Chairman, this is a roll call vote on Senate File 14. Senator Boner,
Aye.
Senator Case,
Aye.
Senator Nethercott,
Aye.
Senator Scott,
Aye.
Chairman Driscoll.
Aye.
That motion passes.
Which of you would like to carry it on the floor? Don't run away, Senator Case. Senator Nethercott, we will hand this one to you on the floor. Thank you very much. Our next bill will be Senate File 18, Universal Occupational Licensure. And I don't know who we have to present this either, back to not being very well. Senator Case or Nethercott, who should be presenting this bill? I'm leaning on you folks pretty heavily. I realize. Thank you.
Well, thank you, Mr. Chairman. During the interim, I'm trying to remember where it came about. I believe it has something to do with the department, the military department, and Chairman Lindholm had a lot to do with moving the bill forward.
Mr. Chairman.
Senator Nethercott.
Thank you, Mr. Chairman. The purpose of this bill and this particular amendment really does stem from F.E. Warren Air Force Base here in Cheyenne, which is one of Wyoming's largest employers in the state. And Wyoming has been downgraded by the Department of Defense associated with maybe some of our laws associated with unfriendliness associated with a licensure for some professionals. And so this bill strikes a balance between our licensing professionals and the needs for military spouses who have professional licensures to be able to get licensed quickly and readily to join our workforce and provide those necessary services. So this bill is a reflection of work in the interim and strikes that balance between our professional occupations and those military spouses. So there's no extended delay for them when they move here in order to practice their professions.
Very good. Thank you. Would you like to walk us through the bill, or do we have staff to walk us through?
I'm happy to walk us through the bill, Mr. Chairman.
Seems to be a pretty simple bill, but I'm loath to try it by myself without help. Thank you.
Absolutely, Mr. Chairman. So we have Senate File 18, Universal Occupational Licensures. And really the onus of the bill, if we look at, well, let's start on pages 1 and 2, professional and occupational licensure for qualified individuals licensed in other jurisdictions. So we start from the premise that this bill addresses those professionals that actually have licenses in other jurisdictions. And so it really is more of a reciprocity type of a concept associated with the purpose of the bill. As we move into page 2, we're talking about active licensure of those professionals, as seen in the definitions, that they're an applicant in the state of Wyoming with their active license from another jurisdiction. And that on page 2, lines 18 to 22, we're dealing with a professional or occupational licensing board shall issue a license to an applicant to allow the applicant to lawfully practice a profession or occupation requiring licensure in the state of Wyoming. And then here are the requirements associated with granting an applicant a Wyoming license based on that other state's licensure. And here are those standards that are found currently in Wyoming law throughout page 3. And we move down into page 4, and there's additional requirements that are currently in our law and what we do. And the heart of the bill can be found on page 6, which is lines 4 through 10, which really deals with temporary permits for military spouses. Again, the Wyoming legislature already recognized the need for this for military spouses, so this is already in our law. But these are necessary changes that have been identified by the Department of Defense and our military here present in the state of Wyoming to allow for an expedited license, recognizing the need for these military spouses to get to work and be able to contribute to their families and to our workforce here in Wyoming. And then striking the language, moving down the page on lines 14 through 19. And it really kind of cleans up some of that language, allowing for the expedited licensure. And so the language that's being repealed is which state mandates, and I'll just read the whole section together, holds a relevant active occupational or professional license in good standing from another state. And that's where the concept would end. And the language that states which state mandates substantially equivalent or more stringent educational training, examination, and experience requirements for licensure. Substantial equivalency shall be determined pursuant to the rules which shall be adopted by the licensing board from which the military spouse applicant seeks licensure. And so that language has been stricken really to allow for a less cumbersome and direct directive from the legislature about how that expedited licensure should take place. Moving down onto page 7, lines 6 through 8, that temporary license is going to change from 120 days to really 3 years. When that licensure applicant, a military spouse, is in the progress of getting full licensure in the state of Wyoming, this really allows for them to get to work on whatever unique licensure requirements are associated in the state of Wyoming. And that 3-year period also acknowledges what might be that military spouse's temporary residency in this state while they're being stationed here. There's also a lot of challenges associated with that as these military spouses move from state to state. The need to keep up the regulations or their educational requirements from state to state, and a failure to do that can result in damage to their license. This kind of provides that umbrella concept protection for a period that they might be stationed here. Limitations on what the board can charge the military spouse on a temporary permit. So they still are required to pay the application fees associated with licensure in the state, but there's no additional fee for a temporary application. There's a requirement here on lines 14 through 21 that the licensing board must inquire and maintain a record to ensure that it is actually a military spouse who's asking for the expedited temporary license, and any identification requirement associated with that is certainly appropriate. And that, Mr. Chairman, is the bill, and I stand for any questions.
Great job. Questions from the committee? I have one. Spouses only, what happens if we have a military person themselves that would want to perhaps moonlight or do something on the edge? Are they prohibited from doing that, or could they be a spouse on the other end and still make it work?
Mr. Chairman, my understanding is I think they'd be prohibited from doing that, from moonlighting in another occupation. So if they have a licensure and they're a military member, active military member, they're likely providing those services to the military in that capacity. Senator Boner was an airman, though, and I think he probably wants to comment on his understanding of licensure when he was an airman. So perhaps Senator Boner can provide more information on this.
Senator Boner.
Thank you, Mr. Chairman. The way I remember this working, it has been about 10 years now, but you do need permission from your commanding officer to take on a second job. The only concrete example, I remember one of our chefs in one of our missile squadrons worked at a restaurant, when he wasn't out in the missile field. I think it's extremely unlikely that somebody who would require a licensure would also be pulling double duty like that. It's mostly junior enlisted personnel who are going to spend blocks of time out in the field, then blocks of time back on base. So it would, with the permission of their commanding officer, would be taking a second job. So I that's a good question, but I'm not sure if it's going to come into play when you think about, say, somebody in the medical or legal profession. They're going to be full-time working for the military, probably not going to be doing something in town.
Yeah, actually, I'll follow it just a little. Medical is exactly where I was thinking, is if you have doctors on the base that potentially might want to be part of an emergency crew or something of the sort, whether they're licensed to do it, because we're we're certainly short of them, and I wanted to make sure that if there's a way we could do it, that they could be included as well. They're great people often. Senator Scott?
Yeah, Mr. Chairman, the first part of the bill is a little more general and doesn't just apply to the spouses, and that could potentially be an avenue. It's gradually, I think, the first part of the bill makes it easier for anybody to come in these various occupations, but the occupations themselves have been working on that, and for many of them, it's going to be moot. For others, it's going to be important. So there is an avenue there if that circumstance you're talking about arose, where this bill would be helpful, but it would be helpful to somebody who wasn't in the military too.
Thank you. Further questions for the committee? Further questions for the committee? We will open up to testimony then. I think we have Representative Ocean, who I know is going to bring a amendment, but would you like to comment in general on the bill first? You'll need to unmute yourself.
Thank you, Mr. Chairman.
Welcome to the Wyoming Legislature, and I assume your first committee meeting.
It is. Thank you. I want to first thank the committee for hearing Senate File 18 and addressing the very important issue of occupational licensing recognition. I have a modest amendment that strengthens the bill. My amendment treats occupational licenses the same way that Wyoming treats driver's licenses. Someone from Idaho who holds an occupational license should be able to obtain a similar occupational license in Wyoming with the same simplicity as obtaining a driver's license. When someone gets a driver's license, the agency does not scrutinize the scores that the driver passed the test with in the other state, the law of the other state, or the content of the driving school curriculum. The benefit of this amendment is that it is less burdensome on both the applicant and the agency, while equally protecting consumers by requiring 1 year to compensate for any differences in licensing requirements. This amendment will help with getting people back to work, fulfilling employers' needs for skilled labor, and all while respecting other states' laws as we would with driver's licenses. It's important for me to mention that Arizona, Pennsylvania, Missouri, and Iowa have enacted bills on the model I used to write my amendment. Last night, you received a letter from Heather Curry from the Goldwater Institute explaining the success in Arizona, where boards have approved over 2,400 applications in this process. Also, there are legislators in at least 10 other states who will introduce legislation in 2021 similar to my amendment. And if it is all right, Mr. Chairman, I'd like to walk through the amendments.
You're muted, Mr. Chairman.
Thank you. Representative Ocean, the actual amendment will come up when we work the bill as general comments, and I'm glad that we brought you in. We'll read the amendment in when we're done with public comment, and we've actually moved the bill. So hang tight. We'll bring you back in, and everybody's kind of aware of what's coming now, and nice job. If you have further comments, we'll do it real quick. If not, we'll move on to more public comment.
Thank you, Mr. Chairman. Sorry if I jumped ahead too quickly.
You didn't. I kind of let you run into that. So next up, I see we have Ms. Urbakite. Do you want to comment?
Good morning, Mr. Chairman. Yes, I do. Lori Urbakite with the Wyoming Realtors. And we are supportive of this bill as it is currently written. I've not seen the proposed amendment, so I can't speak to it. But the paragraph D on page 4 is of serious importance to us. We have, when we license real estate practitioners in Wyoming, we take a universal test, and then we also take a state of Wyoming test that tests specifically for Wyoming state statutes. Our license law for real estate practitioners is different than other states. The easiest explanation is on the discussion of agency, whether you represent a buyer, a seller, or you're a transaction broker. These are, or an intermediary. These are terms that are not used in some other states. They have different definitions. We do not allow dual agency in Wyoming, and many other states do. So we think it's important that anyone practicing real estate in Wyoming would understand those particulars of our state law. So this provision allows us to test on the actual Wyoming statute. And we are, with that paragraph intact, we are supportive of the bill. And I'd be happy to try and answer any questions.
Thank you, Ms. Eberkite. Any questions from Ms. Eberkite? Thank you. Oh, Senator Boner.
Thank you, Mr. Chairman. I think I understand the military aspects in the latter part of the bill, but I'm just wondering about the effect of that first part that applies to everybody more generally. There's just so much leeway given to our boards. I'm wondering what the effect would be of this bill outside of military spouses. So maybe Ms. Eberkite could answer that question in the context of realtors.
Mr. Chairman, years ago, we had we had cooperation amongst the states, and we were at one juncture very proud that we had cooperative agreements with all 50 states and a couple provinces in Canada, where we readily accepted their licensing license law as long as they passed the Wyoming statute. So this really doesn't, it kind of takes us back to where we were, but as long as they are, as long as we're able, they have a similar test. And again, the universal portion, I'm relatively certain is the same test nationwide. So if they pass, if they have an existing license in a state and they're in good standing, as far as the Real Estate Commission for Wyoming is concerned, we don't have a real problem with this bill as long as they pass the Wyoming portion as well.
Thank you. Further questions from Ms. Eberkite? Thank you very much. Next, we'll have Ms. Somerville. Welcome to Senate Corporations.
Thank you, Mr. Chairman. Andy Somerville, representing WAMSAC, which is the Wyoming Association of Mental Health and Substance Abuse Centers. And we just had a few quick comments. Generally, we're supportive of the bill. Again, as long as if they're going to stay, they do get through the Wyoming requirements. But we do think it's important for military spouses, especially in our Cheyenne area, for workforce development, to give our military spouses as much flexibility to get to work right away in our mental health field as we can. So with that, I would stand for any questions.
Thank you. Questions for Ms. Somerville? Thank you very much. Testimony is appreciated. Next, we'll have Chris Smith. Chris, are you ready? Unmuted and ready to go. Welcome.
Thank you, Mr. Chairman. I'm Colonel Retired Chris Smith. I'm the current General Counsel for the Wyoming Military Department, the Wyoming National Guard, formerly a colonel, and I've worked with many of you on many bills over the years in different contexts. I just wanted to testify for a moment, just a little bit of background. The section that dealing with military spouses, 33.1.117, was actually passed back in 2013, along with a companion bill that created 33.1.116. In answer to the question the committee had about military members, 116 actually requires licensing boards to consider the experience of military members in licensing decisions. And to date, in my limited experience, we haven't had any problems with that. We've had a number of, to answer the specific question, we've had a number of doctors, PAs, nurses, nurse practitioners who are credentialed by local hospitals and work there through a licensing deal. So really that has not been an issue with medical professionals in the military. We actually do that quite a bit for additional training. Back in the interim to the lead up to the 2018 session, we actually had a report where we we had someone look at all of the licensing boards we could identify. And if I recall correctly, there were over 45. And all of them expressed at that time a willingness to do whatever they could for military spouses. As Senator Nethercott explained well, military spouses come into the state 3 or 4 years, and then typically following their spouse's reassignment, they leave. So anything that this body can do to assist them in becoming licensed, so they're not waiting for up to 2 years in some cases in the old days to get a license to continue their career as they follow their military spouse, is very helpful. In looking at this bill, the first part of it is very broad. I know from the testimony we had back in 2013 and back in 2017 that as long as the substantial equivalent language is in there, which I think it is on page 4, I would imagine the boards won't have any problem. I recall very well Senator Pappas, an architect, being very concerned about just giving a license to any architect, because an architect from the southern states doesn't have to worry about wind and snow load like an architect in Wyoming does, just to use that as an example. But the bottom line, sir, I do want to say that Major General Porter, the director of the military department, wanted to be here, but he had a conflict. We are supportive of this bill. It generally applies in the most part for active duty spouses on FE Warren, but we do in the Guard sometimes pull people on orders. They call it active Guard reserve orders in the Guard from other states, and it would apply probably less than a dozen times in a year to your National Guard as well. So we are very supportive of the bill. With that, sir, I'll stand for any questions.
Senator Scott, thank you.
Mr. Chairman, thank you. Am I right in thinking that for active duty, the military individual themselves, that this bill, particularly the first part, has some implications when somebody's getting set to retire and go practice their profession? Once they've left the military, it makes it easier for them to get in, and has an advantage in that area for the professions that aren't as far along as some of the others, like the doctors are, in terms of their interstate compacts and licensure.
Mr. Chairman?
Go ahead, Mr. Smith.
Senator Scott, it does, sir. And it would help that dramatically. I would call the committee's attention again to 33-1-116, not in this bill. And that passed back in 2013 was a great bill in my opinion, because it required boards, as most of them already did, to consider military education, experience, training in the granting of license. The language in this bill at the first part in section 1 does exactly that. So this only would assist even more in our military members who this body has been very supportive over the years, and we certainly want to retire or separate and stay in Wyoming, as I did when I left active duty back in 1998. And so I think this bill would assist military members coming off active duty.
Thank you, Mr. Smith. Any further questions for Mr. Smith? Thank you.
Thank you, sir.
Testimony is appreciated. Mr. McGrath, are you ready?
Mr. Chairman, I am ready. Thank you. But if you would indulge me, sir, I prefer to wait until after Representative Andrew presents his amendment, because my testimony focuses on his amendment.
Absolutely, we will do that, please, sir.
Thank you, sir.
Ms. Ebke.
Thank you, Mr.
Your name right?
That's very right. Yes. Thank you, Mr. Chair. Like Mr. McGrath, I think I would prefer to wait until after the amendment is presented, if that's okay.
Very good. No problem. We'll leave you both in the room. With that, I think we are through the public testimony. Seeing no more, we will move back to the committee. We have a motion on the bill.
Mr. Chairman?
Yes.
Sorry to interrupt, but it looks like there is an additional public comment.
There is. We will. Ms. Peralt? She is muted.
Good morning, Chairman. Thank you for the opportunity to be here today. My name is Tammy Pro, and I'm with the Department of Defense. I represent the Northwest region and the Defense State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. And I'm here to provide testimony in support of Senate File 18. Our mission at our office is to serve as a resource for state policymakers like yourself as you work to address quality of life issues for service members and their families. And licensure has been an important part of that for the past several years. We are concerned about licensure portability for military spouses because it impacts our retention rate for our service members. Our military service members and military families depend on two incomes sometimes, just as any family in the US does. As our military members and families move from state to state, transferring their licenses in order to obtain employment at their new military assignment is important for their career sustainability. And policies to enhance existing licensure provisions for military spouses serve to relieve one of the many stressors of frequent military moves. So we thank you very much for considering this legislation. Wyoming is home to over 1,100 active duty spouses. Approximately 34% of those military spouses in the workforce are in licensed occupations. And currently, approximately 19 states, not approximately, but 19 states have incorporated language to ensure military spouses can more quickly obtain an occupational license based on licensure in a previous state. Thus, we ask Wyoming to consider this helpful policy language. We're grateful for the efforts that Wyoming has historically made in support of military members and their families, and we appreciate the opportunity to support Senate File 18. Subject to your questions.
Thank you. Sorry about butchering your name, Ms. Peralt.
No problem. Thank you very much, Chairman.
Questions? Very good. Thank you very much. Next will be Mr. Boner Blessed. I'm pretty tough on names here to get it right, sir.
Mr. Chairman, it looks like Senator Scott has a question of Ms. Perot.
Oh, I'm sorry. Senator Scott. Sorry I missed you.
Yeah, thank you. Mr. Chairman, the question I have for her is, when the Department of Defense is considering whether to expand or close down a base, they do put some weight on this whole business of military spouse employment opportunities, do they not?
Through the chair, Senator Scott, yes, there has been some weight put on this issue. This issue has come up through the Air Force primarily over the past year and a half, and the Air Force has considered this through as part of their basing decision criteria and made this very public. So this was something that our previous Secretary Esper, had considered and asked the services to consider as they were making basing decisions. Although this is not going to be a key criteria, it's going to be something that they do look at when they're making basing decisions.
Thank you. Further questions? Thank you very much.
Thank you.
Mr. Bonin Blessed. Tough on names. Welcome.
Thank you, Mr. Chairman.
Perfect.
Thank you, Mr. Chairman. You did really well that second time, so thank you. I'm Kevin Bonenblust. I'm the Executive Director of the State Board of Medicine. I hadn't planned on testifying. We did submit a fiscal note. We will, if this is enacted, we will have some programming things we have to do within our systems to be able to track some of the information we're required to for military spouses and that sort of thing. So it's not just simply a matter of, oh, we'll just start doing that. The information systems have to be adjusted. I was concerned. I've not had an opportunity to see Representative Ocean's amendment, although I think I have a general idea what it's about. But I kind of feel like if the licensing boards and so on haven't seen it, I'm a little concerned about what the content is. So I can't testify to it, but I've heard of similar things from various places, and I'm not sure that, but what that may go past the scope of enhancing, opportunities for military spouses. So I just indicate not having had a chance to review that language. I guess I'd like to reserve judgment on what comments might be made. I wish I could be more precise than that.
Mr. Bonin blessed, we will leave you in the room as well. I will allow some comments on the amendments as we come from the public. Any questions? Any questions? Okay, with that, I do believe I see no hands up. We will move on to the bill. Committee, what's your pleasure on the bill?
Move the bill.
Seconded by Nethercott. Bill has been moved and seconded. We've worked through the bill. I think we'll just go ahead and jump right into the amendment. We've run through the bill. Representative Ocean, would you like to go through your amendment at this point in time? And do we have written on it, staff? I probably do, and I haven't seen it.
Mr. Chairman, I believe Danielle Creech did forward that proposed amendment to the committee members here.
Perfect. Thank you. I'll dig it up. I've only got my phone and a computer. So Representative Ocean, if you would like to go ahead and walk through the amendment.
Thank you, Mr. Chairman. On page 1, if you look at lines 8 through 16, lines 8 through 16 treat the licenses of military personnel the same as licenses from other states, which, as we move further on in the bill, this actually creates an easier process for military personnel to get their licenses, and military spouses as well. Lines 31 through 35 require that the applicant have a valid license with a similar scope of practice from another state. Moving on to page 2, lines 1 and 2 require that they have held the license for at least 1 year. Lines 4 and 6 require that we know that the other states properly vetted the applicant. Lines 8 through 9 require that the applicant be in good standing with the other state. Lines 11 through 12 require that the applicant have a clean record. Lines 14 through 16 require that the applicant's license has not been revoked. Lines 18 through 20 require that the applicant has not committed misconduct. Lines 22 through 30 require that there are no pending complaints, allegations, or investigations against the applicant. Lines 35 through 40 allow the licensing board to require passing a jurisprudential exam, which addresses the concerns of many of the people who testified on the bill, that these people need to know Wyoming law. Lines 42 through 44 require that the board complete the process in a timely manner of 30 days or less. Moving on to page 3, lines 1 through 5 require that the applicant abide by the law in the same way as everyone else and are subject to the same disciplinary actions. Lines 13 through 14 state that we are not limiting the rights of military personnel under existing statute. Lines 16 through 17 state that we are not changing the process for unlicensed people. Lines 19 through 21 state we are not preventing the state from entering licensing compacts. Lines 23 through 26 state that we are not tying the hands of the agency in what they may recognize. Lines 28 through 29 state that private certifications are unaffected. Lines 31 through 33 define a reasonable fee. And the last part, the emergency powers section, allows the governor emergency power to recognize licenses and to expand the scope of licenses if needed. And that is the amendment. With me, I have Lee McGrath, the managing attorney at the Institute for Justice, and Laura Ebke, a former state senator from Nebraska, to also testify on the amendment. Thank you, Mr. Chairman.
Thank you. We'll just go ahead and move on to them, and we'll do questions for all three of them together. Mr. McGrath, would you like to comment?
I would, Mr. Chairman, and thank you very much for the opportunity to support Representative Andrews' first endeavor in the Wyoming legislature, and a good one. My colleagues at the Institute for Justice and I support the amendment for two reasons. One is that it removes an unnecessary statutory comparison that is in the bill, and two, that it promotes freer labor markets in Wyoming. Let me dive into each of those dynamics. It's important on page 3, line 3 of the bill to see that the bill does not look at human beings when making this comparison. It doesn't look at that military spouse or that doctor. It instead looks at one state's regulation versus another state's regulation, and burdens the board with the responsibility of analyzing whether they are substantially equivalent or not in terms of education, training, examination, or experience. Representative Andrews' bill takes this out and uses the driver's license idea much more effectively to reduce costs. Someone would come into Wyoming and get a fairer treatment. They would show up in Cheyenne and show that they have a valid license that has not come under scrutiny for negligence, and they have 1 year of work experience. And that 1 year of work experience covers any differences that might exist, and eases the administration. Let me give you an example of that, Mr. Chairman. To get a cosmetology license in California requires 1,600 hours. That's less than Wyoming's 2,000. To get the same license in New York or Massachusetts requires 1,000. So a world-renowned stylist like Jen Atkins, who does the hair of movie stars, in theory, if she wanted to move to Wyoming, would not be able to would not qualify because she doesn't have substantially a significant number of hours. But she has 20 years of work experience, which this statutory analysis doesn't take into consideration. But Representative Andrews' bill does take into consideration that the work experience compensates for any differences in statutes. The second point, Mr. Chairman, is that this is an important labor market reform. Wyoming is a right to work state, and licensing actually is 4 times as large issue in labor markets as unionism is. In Wyoming, you want to get people back to work. You want to attract new workers to Wyoming. You want to create opportunities for workers and entrepreneurs. Looking at occupational licensing is critical to all those functions. And so, consistent with Wyoming's right to work status, Representative Andrews' bill addresses the problems that licensing causes. As a first step, it addresses the fact that licensing causes higher unemployment, higher prices, less economic activity, and fewer opportunities for those without means. This bill should be a first step for the legislators to review whether Wyoming can increase opportunities by reducing regulatory barriers to entry. I support, my colleagues and I support enthusiastically Representative Andrews' amendment to the bill, and it's a friendly amendment, completely consistent with the concerns that our friends at the Department of Defense have articulated, and completely consistent with the advocacy of Labor Secretary Scalia, who has been a strong voice for this type of knocking down the interstate movement of workers. Mr. Chairman, I'd be happy to answer your questions, members' questions about my law firm, the work that we do at the Institute for Justice to promote free labor markets, or about the good work in Representative Andrews' amendment.
Questions for Mr. McGrath? Well done. Thank you.
Thank you, sir.
Ms. Ebke?
Thank you, Chairman Driscoll and members of the committee. My name's Laura Ebke. As you heard, I am a former state senator from Nebraska. I'm also currently serving as the senior fellow at the Platt Institute, which is a free market public policy institute in Nebraska. At the Platt Institute, I focus on job licensing and regulatory reform. Served for 4 years in the Nebraska legislature, where I was the primary sponsor of one of the first major occupational licensing reform bills in the country in 2018. And one of my responsibilities with the Platt Institute is to lead our multi-state licensing reform effort and to provide advice and assistance to legislators and state policy organizations working in this area. Hence my appearance before you today. I always think that's a good idea when I'm testifying in another state, because I was where you were once upon a time, and I wondered why these people were coming to talk to me from out of state. Senate File 18 is part of a family of occupational licensing reform bills that are being introduced all around the country. As has been noted by Representative Andrew and my colleague, Mr. McGrath. Depending on how you count, there have been 9 or 10 states that have put some sort of law in the form of universal recognition into place. And there are at least 10 more states that have bills that either have been or will be introduced during the current legislative session. That's in addition to the 5 or 6 states that have enacted comprehensive review bills requiring periodic reviews of all occupational licensing in the state. And I would say that if something like that comes before you, I would love to come and talk to you about that again. Occupational licensing reform is an area of really great interest around the country, and it is a bipartisan effort. You see it throughout the country. The amendment that Representative Andrew has provided you makes SF 18 an even better bill. It's incredibly well written. It's concise, easy to understand. It removes the authority of licensing boards in determining when licenses from outside the state should be accepted, and it puts it in the hands of the legislature, which I would argue is where it belongs. It is, after all, the legislature which decides when to license an occupation. It should also rest with the legislature to decide how to license an occupation. It also saves the added cost of licensing board staff time as they try to compare licenses across state lines. The comparison made to driver's licenses is, I think, appropriate. No matter the occupation, if an individual is licensed in good standing and has experience in their previous state, it is to the benefit of the state of their new home to get them authorized to work as quickly as possible. My husband served in the early 90s before many of the motor vehicle or driver's license compacts were in effect. He served in the military. We started in Omaha, moved to Memphis, Tennessee. I walked in with my Nebraska driver's license, and they ran it through their Magical Computers found out that it was in good standing and issued me a Tennessee license. 2 years later, I went to North Carolina and did the same thing with my Tennessee license. And when I returned to Nebraska, they did the same thing with my North Carolina license. It ought to be that easy. States like Wyoming and my own home state of Nebraska have much to offer people who are looking for, kind of wide open spaces. We ought to make it easier for them to be contributors to our economy. And if we do that, they're more likely to join us in our great state. So I thank you for allowing me to join you today, and I'd be happy to try to answer any questions you might have.
Committee questions for Ms. Ebke? Seeing none, thank you. Mr. Boner-Blust.
Chairman Driscoll, thank you. Again, Kevin Boner-Blust, Executive Director of the Board of Medicine. And I want to apologize to Representative Andrew for fouling up his name. I'm always very careful about names, and so I apologize for that. I guess a few points. First and foremost, the reason you can take a driver's license, go state to state, is because of interstate compacts. And as Senator Scott knows, licensing boards in Wyoming have been working very hard to get interstate compacts in place to speed licensure, to make it easier to get people working in our state in professions. As a matter of fact, a third of the physicians we licensed last year in Wyoming came through our interstate compact, which was a far faster process than ever existed before. So in some ways, this issue has already been addressed and is being addressed by legislation for boards. I would also indicate that while I appreciate Representative Andrews' outlining of the amendment, I always prefer to read the language myself and make sure I understand what's being said, because with all due respect, we read words differently sometimes and maybe don't know the impact of them. So I would really, I would encourage the committee to at least let this go until it goes over to the House committee, so that interested parties, not just those advocating for this amendment, know what it says and have an opportunity to speak knowingly on it. And then finally, I think this is, it was rather telling that Mr. McGrath described this as a bill. He referred to it as a bill several times. My recommendation is, I think it should be a bill. I don't think this is geared to military spouses, which is the origins of the bill. And the Joint Committee worked this bill all through the interim. And now the night before you hear the bill in committee, you've got what basically is another bill in front of you. I would encourage you, if it's a really good amendment, have it brought in the House when there's been an opportunity to comment on it, rather than have it be, sort of a 11th hour type thing. So again, I'm flying blind here. My apologies to the committee for not being able to speak more directly to it, but I think that right there is the essence of the problem. So with that, Mr. Chairman, I would take any questions.
Any questions? Thank you. I think we're through with testimony. Would anyone like to move the amendment? Senator Case.
I'll move it, Mr. Chairman.
Amendment's been moved. Do we need a second in this committee?
Mr. Chairman, that's up to the committee. You as the chairman. In the Revenue Committee, we don't require a second because we figure we only have 5 people, but this committee, it's totally up to you. I think Senator Landon was of the opinion and required a second.
I am comfortable. We'll go on without the second, unless there's anyone on the committee have comments on that. Okay, we will go on without a second then. We're at discussion on the amendment at that point in time. It's been moved. Committee discussion on the amendment. Senator Scott.
Mr. Chairman, and let me say I'm in general in sympathy with where the amendment's trying to go, but I have a reservation. I think the key part of the bill is on page 3, the single I and then point A under it. What we've seen in the past in this area and is that the problems in this area with educational equivalency has been where a licensure board wants to see a specific curriculum before they'll grant reciprocity. And that causes major troubles for more experienced applicants. They have trouble getting the information as to what the specific curriculum they took was. Fashions have changed and new requirements come in as our knowledge expands, particularly in the healthcare area, that people that are already in practice pick up from experience. And it's been a major barrier. This bill mandates substantial equivalency, and then for educational equivalency, which is where the problem has been, it says it's determined by whether the degree required is doctorate, master's, bachelor's, etc. That solves most of the problems. People have the requisite degree. If you eliminate their ability to look at those factors, you have the potential for getting real opposition from some of the licensing boards where the level of degree that's held gets to be very important. We've had a lot of experience in the mental health area recently with this being a very contentious issue. And so I did hear them in things like the cosmetologist, where it's at so many hours of training, it's the issue. I don't have a good solution to that particular problem right now. It has been not, as in my experience, as great a problem as the curriculum stuff where they go beyond the degree and look at what the curriculum was. Frankly, to use a military analogy, I would describe this amendment as being a bridge too far. I've got many years of scars from licensure battles, and I can tell you, if you rouse some of these professions that their profession is threatened, the lobbying gets to be just amazing, and people seem to be content with this version, which is a substantial step forward. And I'm afraid if we took the additional step this amendment takes, we would rouse opposition that might kill the whole bill.
Thank you, Senator Scott. Further comments? Further comments? Senator Boner.
Thank you, Mr. Chairman. I don't have much to add to Senator Scott's perspective. I'd just like to commend Representative Andrew for bringing the idea. I do think it'd be better off as a separate bill. It is a pretty significant change. I want to commend adding the Space Force military of definitions. That's definitions of military. That's good, but I have concerns about including state militias and stuff like that. So a good starting point, but I just highly recommend that Representative Andrew coordinate this with the people who are going to be affected by it, especially some of our more significant boards like the medical board. So in opposition to the amendment.
Thank you. A huge thank you to Representative Andrew. I'm going to do something we don't do all the time. I'm going to go ahead and let you have one more bite at the apple if you want. You probably won't get this in the future at most committees.
Thank you, Mr. Chairman. I just wanted to address two concerns really quickly. It was mentioned that there are already interstate compacts to address some of these issues, but those only exist for very few professions. And so this amendment opens it up to more professions such as cosmetology, as Mr. McGrath mentioned. To also address the equivalency of education, that is why the amendment requires at least 1 year of experience, because 1 year of experience in the field of work makes up for any difference in the requirements state to state. That's at least 2,000 hours of experience in in that field. I also do not feel that this changes the subject of Senate File 18, because the first part of Senate File 18 addresses this very issue of providing a path for license recognition. I just believe that the language in my amendment makes it less burdensome on both the agency and the applicant. Thank you, Mr. Chairman.
Thank you, Representative Andrew. Any further comments from the committee? All in favor of the amendment, raise your hand, please. We have 2, counting myself. All opposed? 3, the amendment has failed. Thanks for your try. Hopefully we see it back as a bill. We're back on the bill. Any further comments on the bill? Question being called. Roll call, please.
This is a roll call vote on Senate File 18. Senator Bonner,
Aye.
Senator Case,
No.
Senator Nethercott,
Aye.
Senator Scott,
Aye.
Senator Driscoll, Chairman Driscoll.
Aye. Senator Boner, you get to carry this on the floor. Thank you. Okay, we're on to the next bill. It's a nice short bill that I'm suspicious is going to take a little more time than the last 2. Does anyone on the committee want to take a short break, or are we ready to roll right into it?
About 5 minutes.
Good suggestion. I kind of needed it myself. So it's 9:59. We'll come back in at 10:05. Committee, shut your cameras and mics off, and we'll reconvene at 10:05. Thank you. I think we'll go ahead and start. We're at 10:06. Senator Case will be back within a minute or so. Our next bill will be Senate File 16, new net metering systems. I think for the first testimony, we will go to the Office of Consumer Advocacy. Not sure who we have here. Bryce Freeman, maybe. Mr. Freeman, welcome. If you want to turn your camera on and join the meeting, you're welcome to. We'll have you walk us through what you see on the bill. Also, welcome President Dockstetter to the meeting. We have a watcher.
Thank you, Mr. Chairman. Just joining all the committees today. Thank you.
Great to see you have interest in us. Thank you. Mr. Freeman, are you able to hear us? You're muted and if not, I think we've got someone from the Public Service Commission. I'm not sure who it is that they've sent. Can we go ahead and let them in? Where they're in, unmute. We'll go ahead and. There we go. Welcome. Can you hear me?
Yes, sir, Mr. Chairman.
We'll go ahead and let you give us a general overview and your thoughts on it as far as the bill. It affects you to a large degree. And we'll go from there to Mr. Freeman. Thank you.
Thank you, Mr. Chairman, members of the committee. This bill is basically a continuation of discussions that were had.
You identify yourself. I'm sorry, I don't have your name.
Oh, I'm sorry. I'm sorry, and it's not displayed. I'm Chris Petrie. I'm the Chief Counsel at the Public Service Commission.
I thought, Mr. Petrie.
Not paying attention to the protocols this morning. I'll do better. This bill is a continuation of discussion that's been had previously in front of this committee. Basically, some concerns have arisen, and the Office of Consumer Advocate had previously provided some information on the matter about net metering installations and the way that those are currently handled in utility rates. And the basic concern is that there is a subsidy flowing from customers who do not have a net metering installation to those who do. And that basically stems from the fact that the fixed costs of service are not entirely recovered in the monthly charge or the customer charge for most or perhaps all of our utilities. That means that some of the fixed costs of providing service are recovered through the volumetric or the usage rates that each customer pays for the commodity electricity that they use each month. So if the entire amount of fixed costs is not recovered through the fixed monthly charge, and a customer does not use something in the neighborhood of an average customer's use, which is the whole point of net metering, or one of the points of net metering, then that net metering customer avoids payment of the full fixed cost of maintaining the system that provides service. So the idea here is to charge the Public Service Commission with exploring the existence and extent of subsidies and commencing proceedings to eliminate any subsidies that are found.
Perfect. Questions for Mr. Petrie? Maybe. Senator Scott.
Mr. Chairman, my question is really a quantitative one. When you look at these costs, my understanding is the cost that the utility avoids when they get power from say a rooftop solar or some other customer owned facility, they avoid the power cost of generating that, what would be for utility coal or natural gas cost, or those two would be the principal ones. But all the other costs of the system, including some that would be thought of as not fixed, but the maintenance of the grid, the dispatching of the power, the maintenance of the very capital intensive infrastructure like generating facilities to meet the peak load are not recovered with the by getting the extra power in from the, say, the solar generator, unless it comes in a way that routinely knocks the peak off. So my understanding was that the power cost, the cost that could be avoided by getting solar generated, customer generated electricity in, was in the vicinity of 1/4 to 1/3 of the cost, and the costs that can't be avoided were in the vicinity of 2/3 to 3/4 of the cost. First question is that correct in terms of being the right range on the economics? And the second question is, with these consumer generated facilities, what's the relationship between when they provide power and when the typical peak in Wyoming systems is?
Mr. Petrie?
Yes, thank you, Mr. Chairman. I may miss the question here, Senator Scott and Mr. Chairman, but when we talk about what's, the word avoided in this context is usually in terms of avoided cost, which is the rate that net metering customers are paid for excess power beyond what they use that is received back onto the system. And so that is essentially the wholesale rate. It's the cost that's avoided by the utility by receiving that power from the customer generator instead of from their usual sources. And so my understanding is that approximately, when we talk about one of our large utilities that is just as an example, that a $20 fixed monthly charge only accounts for about 1/3 of the fixed costs of providing service. And so the fixed costs then are all the expenses that the utility incurs, whether the customer uses any power or not. So a successful net meter, in my mind, would be the customer who manages to offset all of the energy that they would otherwise buy from the utility at the retail rate. Some customers produce more, and then their power, their excess power, is purchased by the utility at the avoided cost rate, or essentially a wholesale rate. And as far as the time of production for net metering facilities, there are two common types, and that's wind and solar. And I think that solar seems to be more economically viable and more popular. It's also I suppose easier in some cases because you just need your rooftop. You don't need a pole and a place to put it. So many residences are suitable for solar installations and less suitable for wind installations. And so as far as the time of production of that energy, that's not coordinated with the demand on the system in any way. It comes when it's produced, which is dependent on whether the sun's shining or the wind's blowing. And so this is going to be similar to what you've heard from other states, that it is not likely to function very efficiently as a peak shaving mechanism. It's not going to take the peak demand off the system necessarily, and I think it's fairly unlikely in Wyoming that it would. But I don't have any particular data on the timing of the output from net metering installations in the state versus the demand peak on any of the utility systems.
Thank you, Mr. Petrie. Further questions? Mr. Petrie, I have a couple. One, should this bill pass, is the PSC able to handle with current staffing the increased demands that this is going to bring? And how would you go about doing it? Are you going to bulk them all kind of together, or do these just trickle in and create lots and lots of hearings for you? Thank you.
Thank you, Mr. Chairman. This will require the commission to examine the arrangements, by which I mean the adequacy of the individual utilities' monthly charges to cover their fixed costs. And there would likely be a number of proceedings. I think this is something that the commission is capable of doing, and I don't think it would require any additional staffing.
Thank you. Any further questions for Mr. Petrie? Thank you. I will leave you in the room in case we have further questions as we go on, Mr. Petrie, if you're willing.
Yes, thank you, Mr. Chairman.
We will go on to Mr. Freeman, the Office of Consumer Advocacy. Welcome to Senate Corporations.
Thank you, Mr. Chairman, members of the committee. Thank you for allowing me to be here this morning. This is an issue that we've dealt with for quite some time. I will say at the outset that I'm pleased with the bill that's before the committee today. I think it makes a lot of sense for a couple of reasons. First of all, there is a growing understanding around the country that what we do in Wyoming, which is what was done in the beginning just about everywhere, where you compensate customer generation at the retail rate. Many states have abandoned that already and made adjustments because it just frankly wasn't sustainable. And those states, as they experienced more customer-owned generation penetration, higher penetration levels, primarily rooftop solar, they determined that they had to do something. It just wasn't sustainable on a long-term basis. Currently, I think there's about 13 states that are making this examination, including Wyoming, to see what can be done with regard to net metering. And so I'm glad that we're having this conversation. Most of the activity currently among those 13 states is taking place at public service commissions. And this bill would allow Wyoming to do that as well. And I think that's good because this is fairly complex stuff. It involves cost, determination of cost allocation, cost of service determinations. It can implicate rate design determinations. There's a whole evolving body of research regarding how to fairly and sustainably treat customer-owned generation across the country. And so I think it makes sense to have that sort of a determination made in a forum where you can have experts putting on expert evidence before an expert panel to come up with something that's well vetted, that we can all be sure is fair to all parties, the customer generation owners as well as the remaining body of ratepayers. This is an issue. I've done a fair amount of research in the last 4 or 5 years, and it will eventually lead to rate impacts on customers that don't generate their own electricity. And the ones I worry most about, the customers I worry most about in the state are low-income customers and the working poor customers who generally don't have access to the capital that's required to do this. They live in substandard housing. For example, it's hard to put a solar array on a mobile home. They live in apartment buildings because the arrangement between the landlord and tenant, the landlord doesn't have much of an incentive to do that, even if there was enough rooftop space to really make a difference. So I worry about the low income and poor people in Wyoming that will ultimately be impacted by this as rates increase. So those are things I think that we need to examine in the context of hearings before the Public Service Commission. At some point, and I wouldn't argue that we're there yet, but if you take this to its logical conclusion, at some point you just can't raise rates on non-generating customers fast enough and high enough to make up for the utility revenue shortfall. And that will impact the ability of the utilities to maintain not only the distribution system, but the transmission and generation resources that are needed to serve all customers, not just the people that don't have rooftop solar, but those that do as well. Because when you get right down to it, the only costs that are avoided, as Senator Scott was alluding to earlier, by self-generation are really the avoided fuel costs, because you don't know if a customer who owns self-generation is going to have that generation available on peak. And so the utility, prudently, as the provider of last resort, has to plan its system and reserve capacity on its system to serve those customers when they need energy from the utility. And that's reserve capacity on the distribution system, the transmission system, and generation capacity to serve the customers when they need, the self-generating customers, when they need their lights to be on. So, you know, there's more than one way to skin this cat. Certainly, based on my research, there's a number of ways that you can go about designing a system that's fair to both the self-generating customers and those that don't have self-generation. And we would be looking, I think, in any proceedings before the commission to find out about all of those things that might work in Wyoming. So I'm generally pleased with the bill the way it is, and I would pledge my expertise and support to help the committee with this problem in any way that I can.
Thank you, Mr. Freeman. Senator Scott.
Yeah, Mr. Chairman, Mr. Freeman said a couple of things that I want to ask about because he touched on some of my concerns. And frankly, I represent several neighborhoods. One of them is frankly North Casper, where there are a lot of people that are on a fixed income, often retired people trying to get by on Social Security, which is a struggle. And one of the potential remedies in this area is to raise the fixed monthly charge for being connected at all, because that's one mechanism for recovering the fixed costs. And that would hit those people especially hard. I think the current system where some of that fixed cost is recovered through that monthly charge and some of it is recovered on a volume basis has a certain fairness to it, because the people who use more electricity contribute more to the peak too. But I am concerned that if we don't do something, that fixed charge is likely to go up. My question is, are we seeing that in any other states? And the second question is, if we pass this bill, is that going to drive that fixed charge up? Because are any of the other commissions elsewhere starting to recover more of those fixed costs that way through the fixed charge? So I am concerned that we don't do something, we'll be in trouble. And if we do something, we may be in trouble in terms of our ability to provide electricity to the people really who are in the low income category. And a lot of my constituents are in the retired on Social Security part of that. So that's my concern there. And what's going to be the effect of this bill on those people?
Chairman Driscoll, Senator Scott, thank you for the question, Senator Scott. In my experience and research that I've done, most states have not addressed the rate design, the traditional rate design that's used for recovering costs from non-self-generating customers when they address this problem. It's been the practice of those states and those commissions that have addressed this issue to really address the rate design for customers that have self-generation. So, and Senator Scott, that is a way that it can be dealt with, is you can, for those customers who have self-generation, you could raise the monthly customer charge enough to cover their fixed costs. I would emphasize that's not the only way to address it. And if this ended up before the commission, we would certainly be looking at other ways and ideas that other parties have in the way of addressing this. But certainly there have been states that have done that, that have assessed essentially a fixed monthly charge to customers that own self-generation, so that they are covering all of their fixed costs, or ostensibly covering all of their fixed costs. And that has no effect on customers that don't self-generate.
Thank you. Further questions? Further questions? Mr. Freeman, so the net effect is, as we have more and more systems enter in, is basically all ratepayers pay some more to make up for the difference. They're, at this point in time, they're not neutral on the system. Each layer that adds in adds some more burden to the utility. Is that the crux of your testimony?
Mr. Chairman, that is correct. There is a subsidy that flows from the people with self-generation to those without. Or
Thank
wrong. You. Flows the other way.
Yeah. Further questions from the committee? Further questions? Okay, at this point, we're going to kind of move beyond the two that are here. I'm going to ask first for the people that raise their hands. We've got a couple in the room, either be businesses or industries or organizations, and I'm going to give them a little bit more time, and then we'll move on to the individuals. And we've got lots. I've got probably 1,000 emails or close to it. We want to listen to every person as good as we can. We'll limit the time when we get to individuals, but I'll give a little more latitude to this next layer, which is the utilities, businesses, and people that are that way, and then we'll move on to the public testimony. So I ask for those that raise hands initially in the waiting room that they're either people that do business, it could be installers, it can be utilities, or otherwise, and then we'll move on to the individuals. With that, we'll move to Mr. White.
Good morning, Mr. Chairman, members of the committee. I'm Kyle White, representing Black Hills Energy's some 40,000 electric customers in Wyoming. We are supportive of revising the net metering legislation. In 1978, the federal government, through the Public Utilities Regulatory Policies Act, did require utilities to purchase energy from small generation, renewable generation at an avoided cost rate. The current Wyoming net metering statute actually requires that we compensate customers for their small renewable generation at 3 to 5 times what that federal law would require. As we look at many of the comments associated with why net metering is needed, they talk about the need to address climate change. The net metering is a way to address climate change, but it is not a very good way to address climate change. Utilities, in fact, are adding significant amounts of renewable generation to their system, as has our company when we recently put into service the Corriedale Wind Energy Facility last November at 52.5 megawatts. We believe that the Wyoming Public Service Commission is the proper forum to determine Wyoming customer electric utility rates, including those for all customers as well as net metering customers. We also believe that grandfathering for existing net metering customers under the current conditions is appropriate for at least 10 years because they have made decisions to invest in renewable generation based upon that current statute. We believe the current law is outdated and it is in need of revision so that the electric rates in the state are fair for all consumers. The Wyoming Public Service Commission is charged with determining just and reasonable rates. And in my nearly 40 years in the industry, I've seen them do that quite successfully. Thank you, and I'm available for comments or questions.
Question from Mr. White. Thank you, Mr. White. Mr. Twyford.
Thank you, Mr. Chairman. I'm here to testify in opposition to Senate File 16. I appreciate the opportunity to speak both as a citizen from Sheridan County, as well as a small business owner that is currently trying to bring as many as 24 jobs from the DC Beltway area back into the state of Wyoming. And it is, which is in part why I'm here today to oppose this legislation. I think that Senate File 16 is inconsistent with the Wyoming values of self-reliance, posturing our state and our future economy as one that's resilient, pro-business, and pro-liberty. I think that what we need to do instead is to adapt our economy, our utilities, and our infrastructure, cognizant of the fact that the early 20th century model of electricity distribution is on its way out. It has three parts: the production of power, the distribution of power through the grid, and the final consumer. Where the trend is now is turning that a bit on its head, that the consumers are also producers, and that the old fossil fuel production side of the equation is on its way out. Some of the proponents' arguments point at a couple areas. One is the proximity of the people to the legislature and the PSC's proximity to the utilities themselves. I think that the long line of folks that are lining up to speak would urge the legislature to keep that authority closer to the people here with the legislature. And secondly, to not rush the pack, as Mr. Freeman mentioned, 13 states that are looking at the issue, rush the pack to pull the plug on rooftop solar. A lot of policy is predictability. The idea of grandfathering at a 10-year rate when most of the equations that residential households make is on a 25-year period, which more consistently capitalizes solar investment with the lifetime of that infrastructure, is inadequate. The arguments that this is a subsidy from non-net metered consumers to net metered consumers is partially correct, but woefully incomplete. Senator Scott, as I know from my time interning for him in the legislature in the 1980s, is a numbers policy person, and I appreciate his questions. What I would also offer are some other considerations into the economics of the discussion is not only the cost of the production at the production end, but we also need to look a little more holistically at the peak usage offset. Germany discovered 15 to 20 years ago ways to modernize its grid to take advantage of the peak offset, which clearly common sense shows that if you look at a residential level, air conditioning tends to be one of the highest consumers and peak causes of electrical generation. And that's also corresponds with the peak output of solar systems. Another element of electrical cost is 3 to 18% of transmission line loss by distributing the source of generation at a retail level. A lot of that transmission line loss is abated as well. Another element that's hard to quantify is the overall resilience of a grid, that instead of having a single mega fossil fuel source, has distributed power sources across the grid, is more resilient both for weather effects and also for mechanical material failure or for adversarial use if our adversaries internationally even were to target infrastructure, which, as we know, is a national security issue, is something that's very much been in the books for 20 years. So in conclusion, I am opposed to Senate File 16. I would urge all of the legislators that are considering it to make a vote for Wyoming citizens and the future of businesses like mine, considering relocating to Wyoming as a pro-business, progressive area. We've done so with blockchain. I think we can embrace the future with a post-fossil fuels electrical delivery system. And I would encourage you to vote against Senate File 16 to keep the predictability in place and further encourage the saturation of solar generation for the state. I'll take any questions. If not, I'll allow the next person in line to have the floor.
Thank you. Any questions for Mr. Twyford? Any questions, Mr. Twyford? Okay, thank you very much. We're going to go to a 5-minute limit on everybody here. We've got a long list of people. So from here forward, we'll go to 5 minutes, and then we'll go to 2 minutes when we get to the individuals. So Ms. Anderson, are you ready to testify?
Yes, Mr. Chairman, I'm here. Can you hear me okay? Okay,
I
great.
can. Welcome to this corporation.
Yeah, thank you, Mr. Chairman. Shannon Anderson, representing Powder River Basin Resource Council. Greetings this morning from sunny Sheridan, Wyoming. You'll hear a lot of testimony today about the policy reasons why you should oppose this bill, but I wanted to spend a few minutes to talk to you about 4 specific issues with the text of the bill and to explain why we believe this bill is not ready for prime time. It was rushed during the interim process, and as a result, there's significant issues with the bill's text and will be issues with the bill's implementation if you move it forward today. So the first issue is the timing in the bill. Notably, there is a 6-month gap between July and January. And this means any systems installed after July, but before the new rules are in place in January, have no predictability whatsoever for recovery of that system. That is a significant problem. Additionally, there's only 6 months to do all of the rulemaking and rate making you just heard about from Mr. Freeman and Mr. Petrie related to these new systems. The PSC, as you know, is quite busy already with implementation of last year's House Bill 200. Most of these rulemaking processes over the last few years have taken multiple stakeholder meetings, hearings. It's been a complicated process. And so we urge you to think about the timing in the bill and to make sure that there's adequate time to do the right studies we need to do to get the answers we need to get if this bill moves forward. The second main issue with the text of the bill is the grandfathering section. So for any systems installed prior to July, they are grandfathered into the current statute, but then that statute gets repealed in 2031. So how are the systems that are grandfathered, how do they get moved into the new rules and regulations, the new rates that take place in next January? So it's very confusing to us, like how the grandfather systems actually remain grandfathered, how long they remain grandfathered, and how they're brought into the new conditions under the bill. The third issue with the text is the term public hearing. As Senator Nethercott will know, there's 2 types of public hearings under our Wyoming APA. There are rulemaking public hearings and contested case hearings. These are very different kinds of public hearings. So we're thinking that maybe there will be a rulemaking type process that would be generally applicable to all utilities, to think about the factors and criteria maybe that would determine whether the subsidy exists and to what extent. And then there would probably be a need for contested case hearings related to each specific utility to set the individual rates for that utility related to net metering systems. Again, this is not something that can happen likely in 6 months and should be done deliberately and with caution and to allow adequate time for the right answers to be received. The fourth main issue, as was discussed during the interim session, is an issue with the rural electric cooperatives in the state. As you're aware, the rural electric cooperatives have limited jurisdiction before the PSC, And specifically, the PSC does not have the ability, but for one distributed generation company in Wyoming does not have the authority to set rates for those rural electric cooperatives. So again, maybe the rulemaking portion could be applicable to rural electric cooperatives, but when it gets to the point of the rate making, which is really that question about whether there is a subsidy, how much and how to deal with it, the PSC won't have any jurisdiction at all for those rural electric cooperatives. And that's a problem because right now our statute made a specific policy decision to apply the net metering statute to all utilities, including rural electric cooperatives. So you're pulling the rug out from under anybody in the state who has a rural electric cooperative company that wants to maybe install solar in that service territory. There's a lot of unknowns for that. So those are the four main issues, I think, with the text of the bill. Again, we urge caution. We urge you to vote no today. Let's move it forward, maybe from additional interim study, some other way to really get the right answers we need to get for the state and for the companies and their customers. And finally, I would just leave you with the thought that in utility planning, net metering and distributed generation is typically a demand side resource. It's not a supply side resource. So comparing it to other kinds of electrical generation just doesn't make a lot of sense. And trying to make an apples to apples comparison with utility scale solar or other resources that a utility may install and purchase, it's a different kind of system. And so I would urge you to think about the demand side cost savings aspects of net metered systems, because that's really their purpose within utility planning and economics. And with that, I'd be happy to answer any questions you may have.
Thank you, Ms. Anderson. Senator Nethercott.
Thank you, Mr. Chairman. I do believe Ms. Anderson presented a number of reasonable questions and concerns with the bill draft. And I was hoping maybe if the chairman would allow, we could hear what PSC might share in response to some of those concerns, if we can. I just think we have two pretty sophisticated parties here that can help us navigate some of those concerns more effectively if we can maybe hear PSC or Office of Consumer Advocates as well. I just think those parties are very helpful to addressing some of those concerns right now where they're fresh in our minds.
Mr. Petrie, would you care to comment?
Thank you, Mr. Chairman. First, Ms. Anderson does have a good point about, at least to an extent in my mind, about the schedule that we would be facing here. This would be pretty challenging, and it would require the commission to focus on this and proceed without wasting any time. It is true there would be some need for contested case proceedings, at least unless there's some other approach that might be proposed. The commission has generally taken the approach of conducting some stakeholder meetings or technical conferences at the outset of projects. For example, the House Bill 200 and SF 159 tasks that the commission was given. That is how we're proceeding there. Those are taking a bit longer. I believe them to be more difficult and complicated projects than this would be, although this would involve a larger number of utilities. As far as the commission's jurisdiction over the rural electric co-ops, I understood from the previous meeting and from the applicable statute on the regulation of electrical co-ops that the commission does have jurisdiction over the sorts of changes that might need to be made in order to apply a system to the rural electric co-ops to accomplish the purpose of this statute. What is not regulated by the Public Service Commission when it comes to all of the electric co-ops excepting Powder River Energy Corporation is retail rates, which are the monthly facilities charge and the rates charged for any energy related commodity. And so I'm not sure that that the retail rates definition, which is the part that the Public Service Commission has no jurisdiction to regulate with respect to the rural electrics, is encompasses what would be going on here to address any subsidies that are found to exist in the net metering context.
Thank you. Further questions? Further questions? Thank you. Appreciate that very much. Mr. Petrie, real quick before you leave, would you suggest a longer time frame potentially on that? And second, on contested hearings, is the process not now that you stay under existing until a contested hearing is conducted and done? Thank you.
Mr. Chairman, the process is that, except in fairly rare circumstances where the commission makes some kind of an interim ruling on a utility application or any other proceeding that we have here, what is in place in the utilities tariffs that has been previously approved remains in place until a contested case is complete. And so I guess looking at this statute, I guess I was perceiving some difference between the establishment of the system to accomplish the purpose of this statute and the actual implementation of changes that might be required to address any issues that are discovered. So certainly a different, a more generous schedule would make things easier probably for the commission and anybody else who wanted to participate, just in the sense that this would be pretty tight. I don't think it's impossible, but I think it would be an aggressive schedule.
Thank you. Senator Scott.
Mr. Chairman, question on the timing, which is what raises question from Mr. Petrie. On page 2, line 15, the safety requirements on January 1st, 2022. The first question is that date relevant? And the second question is 3716-104 is not in this bill. It must be existing law relating to safety things. Why is that sentence relevant to this bill at all? Should we solve that timing issue there by simply removing the sentence and letting the safety requirements fall as they may otherwise, because it's existing statute?
Thank you. Mr. Petrie.
Mr. Chairman, I do believe that 3716-104, the safety requirements section under the net metering article, applies to all net metering systems at all times. I'm not sure that it is necessary to call this out. I frankly hadn't thought about that.
Mr. Chairman, if I may, this is Ms. Anderson. Can I try and address that question? And it goes to really my points about the timing. So first of all, you have to remember the statute before you would repeal the existing statute in its entirety. So as of 2031, the net metering statute, including the safety requirements that were just referenced, no longer exist in law. So that's what this bill does. And so that's why it's necessary at some point to bring those safety requirements into the new systems and make sure they're still in place. But again, the grandfathering is still confusing, the timing gaps. I mean, all of these issues are very prevalent with the text of the bill before you.
Thank you. Senator Scott.
Mr. Chairman, question for both Ms. Andrews and the Public Service Commission. I see the problem in the timing where you've got a 6 month gap. I think that is a problem. If we were to solve that by going from July 1st, 2021 to July 1st, 2022, and move the PSC deadline to give them a little more time to April 1st, 2022, would that solve that timing problem?
And Mr. Chairman, if I may, yeah, thank you, Senator Scott. That's a great question. I think you do still have a problem with 105A in that, again, it says except as provided in B, no electric utility shall be obligated under this article to compensate any customer generator for any electricity produced operational from July. And so again, really what you're doing is you're saying as of July 1, if you install a net metering system, you don't know what the rules are. And I would say that, you should get rid of that section A and then, maybe move forward with the rulemaking and all of this other process, and then go back and say, let's address these systems. But if you're saying, from July, we don't know what the rules are, most likely no systems are going to get installed starting in July because we don't know what the rules are.
Thank you. Further questions? Further questions? Okay, thank you, Ms. Anderson. Mr. Kane, are you a installer, a business or something? If not, we'll probably wait a bit.
Thank you. Yes, I am the owner of a solar contracting business in Wyoming.
Perfect. We were desperately wanting to hear from you. You've got 5 minutes and take off running.
Thank you, Chairman Driscoll and committee members. And I don't think I'll even need 5 minutes. Ms. Anderson addressed a few of the points that I wished to address, and I support strongly her comments. My name is Scott Kane, and I'm in Lander, Wyoming. I represent Creative Energies, a solar contractor that's headquartered here in Wyoming. I'd like to just start by saying that I believe rooftop solar serves Wyoming well by driving economic development, private investment, and by reducing the carbon intensity of our electric generation sector. I encourage this committee to discontinue efforts that may result in the reduction of the compensation for net excess generation. If the committee does decide to move forward with the bill, I encourage you to alter the bill's language in several ways. As mentioned, Ms. Anderson has addressed several of those, so I'll skip those topics and address the one that has not yet been pointed out. The bill, as written, directs the Wyoming Public Service Commission in the following way. The bill, quote, says, the system shall prevent subsidization of customer generators compared to other customers of the electric utility. This wording, I believe, presupposes that there is a subsidy to customer generators. My point is that it will be the PSC's job to determine if there is a subsidy and in which direction that subsidy flows. And yet that conclusion is already essentially written into the bill. This, I would suggest, should be replaced with wording that calls simply for fairness between customer generators and non-customer generators. You might consider alternate wording something like, the system shall seek fairness between customer generators and other customers of the electric utility. I believe that would give the PSC an even playing field or a more open-ended directive for what they are being asked to address. I wanted to address additionally specifically that 6-month gap, which Ms. Anderson has raised in her comments. And I do believe that the comments that Senator Scott just made, proposing changes in the dates, along with Ms. Anderson's suggestion of a change to subsection A, which is essentially releasing all utilities in the state from the requirement to compensate for excess generation. I believe if those two considerations were made, that would address this this 6-month gap that has been pointed out. Thank you very much for the opportunity to comment and your consideration, and I'm happy to take any questions.
Thank you, Mr. Kane. Great comments. Any questions for Mr. Kane? Thank you very much. Appreciate your testimony. It was to the point and the way we like to see it. Ms. Kessler, would you like to go next? Can you hear me, Ms. Kessler? Got her in the room. There she is. Welcome, Ms. Kessler. You're muted, I think. We can't hear you. Nope, don't have any audio. I'm sorry. Let's go ahead and skip over. We'll give her a minute to work on it. Ms. Leninger, are you available?
Thank you, Mr. Chairman, members of the committee. I usually would have sat next to my colleague, Ms. Anderson, before you today. I'll just provide some quick supplementary comments. Probably won't need anything more than 2 minutes. My name is Monica Leininger. I'm presenting on behalf of our members at Powder River Basin Resource Council. Thank you so much for the opportunity and continuing to allow the public to access these important matters safely from their homes. On behalf of our members who are both solar owners and non-solar owners, our organization is opposed to the proposed legislation that would unfairly provide uncertainty to the solar industry, hurt jobs across our state, and create barriers for Wyoming citizens and small businesses to have energy choice and independence. I would like to point out to the legislature that though we hear these concerns about cost shifting, we've never chosen to formally study the issue, and therefore we do not know the impact on non-solar ratepayers in the state. Like Mr. Kane said, this bill concludes that there's an impact prematurely before any study. We do know that the number of net metered systems is small and that these systems have negligible costs on other utility customers. We also know that we have less than 1% of rooftop solar energy integration in the state, Mr. Chairman. The Berkeley National Laboratory found that rooftop solar has a minimal impact at anything under 10% market penetration. That level is far higher than where we are today, and this cost shifting is not tangible today, Mr. Chairman, and certainly no reason to overhaul this regulatory system that has worked well to provide certainty for customers and businesses. What is tangible today is the jobs created by the industry and the small businesses that provide these cost-saving opportunities to other Wyoming people and businesses that depend on it. We can create these opportunities for our future, but it does not make sense to move forward with this bill that holds that opportunity back. Other states have had years and years of study on this issue before moving forward. So I would just ask the legislators on this committee to not give up their power to represent their constituents that care about this issue by sending it solely to the Public Service Commission without looking into it first. Thank you so much for your time, and I'll stand for any questions.
Thank you, Ms. Leninger. Any questions? Senator Nethercott.
Thank you, Ms. Leininger, for being here. A couple of, just one comment about that. What's your opinion or your client's opinions about the role of the Office of Consumer Advocate that would be participating in this process with the Public Service Commission on behalf of, I think, the joint interest of those customers, consumers? So just your thoughts on the role of the Office of Consumer Advocate.
Ms. Leininger.
Thank you so much, Mr. Chairman, Senator Nethercott. I believe that the Office of Consumer Advocate would be very important in studying this issue. Many of these questions that have already been asked today, I think the Public Service Commission could be really helpful. I'm purely recommending that we look into this issue by studying it at the Public Service Commission, which the Office of Consumer Advocate is in well contact and collaboration with before we repeal the net metering statute and make these changes that could impact so many folks.
Thank you. Further questions from Ms. Leninger? Thank you. Ms. Kessler, are you available now? Do we have you where we can hear you? Still don't have any volume, at least at my end. I really would like to hear from you. I'm sorry. We'll go ahead and go with Mr. Taylor. If you'd like to come on, we'll just keep working around until we can get to Ms. Kessler. Welcome, Mr. Taylor.
Thank you, Mr. Chairman, members of the committee. Sean Taylor, Executive Director of the Wyoming Rural Electric Association. I'm just going to quickly reiterate the email that I sent to the committee in our support of the bill. And I'll touch on a few things that have been talked about. I do believe the OCA has studied the subsidy issue and has presented that at previous committee meetings. But I would also say if there is a question, if there is a subsidy or there isn't a subsidy, not to diminish the legislature, but I do think the folks that deal with rates at the PSC are the right people to answer that question. So we would support the bill because they're the appropriate body to address rates. For the cooperatives, I would have to push back maybe a little bit on what Mr. Petrie said. We do feel that this is a rate issue, and we would operate as such. For those cooperatives who are not rate regulated, we would develop our own rate class and rate classes, and those rates and classes would be subject to all the provisions under Chapter 17, rate regulation of cooperative utilities. Under that chapter, Section 37-17-104 talks about the adjustment of retail rates, complaints, and investigations and resolutions. And the net metering would be the same as any other rate class in the cooperatives. And they have the ability to first contest a rate to the board of directors, the elected board of directors by the cooperative membership. If there is no resolution between the rate class and the board, they can contest that to the commission and go through a rate case just as they would any other investor-owned utility. And I will say under the Chapter 17, we call it our opt-out law. Since the co-ops, and I've said this repeatedly before this committee before, since the co-ops have opted out, we have not had one rate case or rate issue go all the way to the Public Service Commission. They have gone to the elected board of directors and talked with the management and have come away from those meetings understanding why the rates were set the way they were. And this would be no different with the net metering rate. And so we would certainly participate in anything that the PSC does. But when it came to setting rates for our non-rate regulated folks, we would operate as we do with any other rate class. So with that, Mr. Chairman, be happy to answer any questions.
Questions for Mr. Taylor? Thank you, Mr. Taylor.
Thank you.
Ms. Kessler, are we able to? Okay. Mr. Spears, then, are you an installer or are we on to the public yet?
So I am a business owner and installer here in Cheyenne.
Perfect. Thank you. Welcome.
Thank you. So members of the committee, I definitely appreciate your guys' time today. We've been having these discussions for at least I've been a part of it now for about the better part of 2 years. 2 years ago in 2019 or so, when we first sat down, we sat through a little over 8.5 hours of testimony, roughly 75, 76 people, all opposing the changing of the net metering agreement. This put everything back into the committee's hands to kind of redesign or reword the net metering agreement. It did fail at that point as a tie, which I guess is good for at least the constituents of all of our elected officials to at least hear the issues brought to the table. Then again, last year it was brought up. A lot of the issues were brought up again, many of the same things, and a lot of people squashed the idea. But a lot of the testimonies came into effect of a bill that was completely overhauled in the first, 4 or 5 minutes of that conversation, and then completely rewritten and pushed forward to the Public Service Commission. Some things that we did not touch on today so far is some things that were brought up in the last meetings. Fact of there was roughly 14% of the electricals, or I guess the utility companies, $700 billion in industry is only made up, or the residential is only made up about 14% of it. And there was only about 365 net metering customers. So I think that we're talking about a cost shift that literally has no bearance. And this has been brought up already, but that minimal number. Some things I would like to see brought up is you guys are addressing the cost shift, but we're not bringing up the size of the systems. I mean, we're only allowing a 25 kilowatt for net metering, or it has to go above and beyond. I think there's a lot of things that can be brought up for this. There's a lot of pushback across the entire state about our wind farms and wind turbines that are taking up our skyline of our state. If we increase our cap of net metering to 250 kilowatts or even greater for commercial applicants only, at least at that point, these large businesses are able to offset their electricity through their own solar systems on their own buildings. The idea of having additional solar systems, we already have units across the entire state that are shutting down. Wheatland's shutting down one of their units. Dave Johnson has talked about shutting down one of their units. So we're needing additional power across our entire state. And this is something that can be produced right here and used right here in our own state. So I think that we need to really start considering the fact that the net metering can be adjusted for the commercial applicants as well, and start giving these customers another available location to produce our own power. When we have all these small scale solar systems, you know, whether it be small residential rooftop or commercial grade 250 kilowatts, that power that's being produced is helping offset the demand on our utility companies. So right now, the way the wording reads in our net metering bill that's presented in front of you is that the consumption or the way you're going to pay or not pay for the power that somebody is self-producing is minimal, or not at all. There's talk about in the previous bill that the power that is produced by customers' self-generated solar system on the rooftop would be taken from them during the day, and then anything that they use would be offset through their solar system, but anything that's now at nighttime would have to be charged out at full retail cost. So that power that's being produced during the day, the utility company can take and sell it to the neighbor or sell it to the commercial buildings that are using the power, typically from sunrise to sunset, and make way more than what is being produced to these customers on their systems. So I think the fairness of what's currently there is making it to where it's affordable, not just for the homeowner, but also for the utility company. I think there's a lot of things that aren't being studied, and it's, I think, trying to be careful how I word this, but I think that we need to make sure that we're listening to all sides of this, and when we're developing these policies, it's not being developed strictly through utility companies, lobbyists, but we have 74 to 76 people who continually come in and talk about this stuff. And I don't know anybody else that's been approached or talked to. I know I've extended my hand across the table. I'd love to be able to sit down and help make something that's going to work for anybody if we are going to make some changes in this. But I definitely think that our voices aren't really being heard, and it's still being pushed forward to the Public Service Commission when this stuff is our elected officials' responsibilities.
Thank you, Mr. Spears. Any questions for Mr. Spears? I will make a quick comment as we go. As far as not being listened to, you are being listened to. You know, we've made every attempt to listen, and we'll continue to, right to the point of more time for those of you that do it. And I encourage you to work with your local legislators. Our process really does work and works well. We've, at least for me, and I believe I speak for the other senators on this panel, we strive to be as fair and equitable as we can to everybody. That's the hard decisions we got to make is picking between them all. And that's really a tough one to do. So I thank you for your testimony. Ms. Kessler, are you able to talk to us at this point?
Yes, can you hear me now?
I can. Welcome.
Terrific. Thank you so much. Thank you so much, Mr. Chairman and committee. I'll try to be brief. My name is Steph Kessler, and I am with the Wyoming Outdoor Council. And we are in opposition to SF-16 as it is currently written. William Ruckelshaus, our nation's first EPA director under President Nixon and then President Reagan, once said that data can be like a captured spy. If you torture it long enough, it will tell you anything you want to know. That's how we feel about SF-16 in terms of the way it's written right now. That is actually written for a predetermined outcome, which is to be against rooftop solar. We think that the first indication of this, as has been pointed out, is on page 1, section a, that goes on to page 2. That statement there essentially repeals our current net metering law in effect. It essentially kills this industry 6 months before any study is required to be issued. I've never heard of another study about an economic sector in our state where we want to find out more about it, but we decide to shut it down 6 months before the study is even issued. That will mean that over a dozen small businesses will close down around July 1st. Approximately 150 people who are employed in this industry around the state will be laid off and dispersed and lose their jobs. And then according to this bill, only 6 months later does the PSC even issue the results of its study. The other thing that we have problems with, as you've heard before, but I'd just like to summarize, is that it's a very narrowly focused and biased description of a study. There's no definition of looking at or parameters looking at the positives of net metering aside from the negatives. And the only thing that is considered is what's called a subsidization, even before we know that there is one. And there's no representation in the description of the study of the size, the scale of the impact of that subsidy. If one is even found, does it matter? In 2016, Rocky Mountain Power testified before this committee during an interim session when asked if net metering was creating subsidies in their system. They said it's de minimis. It's too small to matter. We want to make sure that this study is fair and balanced and looks at all sides of this equation here as you study net metering. And right now, this bill doesn't do that and we can't support it. We ask you to kill this bill and take the time to do the research to craft an adequate study if you want to follow this path. Thanks for your time.
Thank you, Ms. Kessler. Any questions for Ms. Kessler? Any questions? Thank you. Glad we got you on.
Thanks.
Mr. Weaver. Welcome.
Good morning, Mr. Chairman, members of the committee. Can you hear me all right?
Yes, sir, we can.
All right. I apologize about the sun coming into the blinds there. I just want to say quickly, I really appreciate the work you folks are putting in for us this morning. I'll keep it short, Mr. Chairman. What I want to speak to you about is city government efforts, and particularly the city of Laramie. I serve on the city council there, and our constituents over the last year and really years prior to that have widely supported an effort to use renewables as a way for the municipal government to maintain services and hopefully, from our perspective, also control costs. I think it's pretty well understood by most of the folks here on the Zoom call and lots of other areas of government across Wyoming, that there's really an expectation and a need for municipal governments to find ways to be more self-sufficient in terms of our own operating costs. And speaking for the city of Laramie, we understand that. It's a matter of budget realities that government at every level in Wyoming is dealing with. At the same time, we also have a responsibility to maintain the expected level of city services for residents at the lowest achievable cost we can find for those services. Quite recently, the city of Laramie has started to utilize some of these renewable energy options to try and help it achieve that. And we've begun to enter into some partnerships with renewable energy providers. And some of these are complete and some of them are in very early stages still, but they hold a lot of opportunity for us in our view. The city needs to keep services on pace with the 35,000 or so residents we have here in Laramie. And I can tell you around half of those folks are either directly or indirectly city utility ratepayers. So anywhere we can find savings at scale, we're going to try to pursue that. The benefits of some of these solar installations that we think they're going to be providing an opportunity for that. That's the big benefit there. And there's a concern that this legislation in its current form could have a negative impact on achieving those savings for residents. City governments, and Laramie in particular, have local partners. I think city governments all have local partners. The regional airports and nonprofit agencies, they're also trying to stretch dollars, and I think they've found similar opportunities. I think there are probably some reasonable questions being raised regarding net metering policies, and I've heard a lot of the commentary here, and it's been interesting and informative. And there likely is a role for legislation, but I want to echo some previous views and ask the committee to consider a deeper examination before a bill is passed. Gather some more information and find ways to get some answers without impacting the ability of the cities and towns to achieve savings, possibly stretch those revenues locally. We're going to need to make every penny count, and the need to do that isn't going to be going away in the near or medium term. And these renewable projects are a valuable option for cities at this time, I believe. I can tell you that our constituents share many of these concerns that you've heard from other folks, and I think you'll continue to hear some of that reflected as you take the testimony here. So I would again just respectfully ask that the committee weigh those concerns as they make their decisions. And I would thank you, Mr. Chairman, members of the committee, for the opportunity to speak. We appreciate it greatly, very much. Thank you.
Thank you, Mr. Weaver. Great to hear the city point of view. Any questions for Mr. Weaver from the committee? Thank you, Mr. Weaver. For those of you in the waiting room, if we're about to move on to people, you can start raising your hands. We'll start admitting you to the room. Mr. Cox.
Yep. Thank you, Mr. Chair. I'll be brief and I'm happy to respond to questions. My name is John Cox. I represent Rocky Mountain Power. I'm here to support the legislation. The original legislation that had been proposed in the interim did have a solution for how to prevent this subsidy. The committee debated this and ultimately decided to do away with that solution and instead direct the PSC to resolve this. And that's the bill that's before you. I appreciate some of the comments that have been made by others. I think some of the concerns have been valuable and are well stated, specifically as it relates to lining up certain dates to make sure that there is certainty in the marketplace, just like with the grandfathering provision, making sure that those who are investing in these resources do have certainty of how that investment will be treated. But I do feel like the language that says or directs the PSC to resolve this in a way that shall prevent subsidization, I feel like that's pretty straightforward. And ultimately, some of the arguments that have been presented today, and I'm sure will be presented later in testimony, argue that very same point. The argument of whether there is a subsidy or how much there is a subsidy. And ultimately, by supporting this bill or approving this bill, the legislature is not putting their thumb on the scale and directing it one way or the other. Rather, they're directing the PSC to create a system or create a process that does not have subsidization. It's the position of our company that a subsidy does exist. Today, we could go out on the open markets or even buy large scale resources, including renewable resources, for significantly less than what our customers pay for this energy resource. In some cases, 2 to 3 times as much is required in this case. And then perhaps just in conclusion, one additional comment that has been mentioned before, but just a reminder, these costs are not borne by my company. They're not borne by my shareholders. They are borne by my other customers. So anytime someone talks about a cost savings, I do just want you to remember that cost savings means that someone else is paying for it, and it's another one of my customers. And we can do this. We can do it the right way. I believe this bill is a step in the right direction. I think there's some ways to improve it, as has been suggested, but all in all, our company does support this legislation.
Thank you. Senator Nethercott.
Thank you, Mr. Chairman. Thank you, Mr. Cox, for being here. Always helpful. So you have identified that the bill might need some amendments, and I think that there's probably a greater level of consensus amongst the two concerned parties here, and I'd like to reach that. And I do fear that as a result of kind of how the bill came through the process, we've created more problems than actually exist. But to identify some of those areas that you agree with that we might need some amendments, I want to ask you about a couple of those. One, do you believe that we need to change the time in the bill, those time marks, in order to address the 6-month gap? And then that's one piece. The second piece is, we heard testimony from Mr. Kane, who owns a business in Lander, Wyoming, where he wanted to change that particular sentence associated with kind of the inference that there already is a subsidy. I heard your testimony that Rocky Mountain Power believes there is a subsidy, but would you be opposed to changing that language to make it state that the PSC is to seek fairness between the parties, if that would be in opposition to you? And then what other concerns do you see in the bill that might need some amendments?
Yeah, thank you, Mr. Chair, if I may. And Senator Nethercott, to those 2 specific points, my comments were directed primarily towards the first comment that had been brought up, I believe, by both Ms. Kessler and by Ms. Anderson, relative to just lining up dates, lining up timelines. I do think it's appropriate to make sure that a customer knows what they're signing up for. They know what the process looks like, and those dates perhaps are not lined up as well as they could be. So I would agree with that. To the second question, on proposed changes to that language on shall prevent subsidization and replacing that word with fairness, our opinion would be that the word fairness perhaps is a little bit of a squishier word. So I guess I would wonder what is intended by that. Ultimately, we believe that a subsidy that's paid by our other customers is not fair. So it seems like that word subsidy is perhaps a better word, but if there's improved language that someone else has, we're certainly open to that. To the final point about any other amendments that I would suggest, I don't have any here today that I'm offering, but I did just want to respond to some comments that had been made that I think were valuable comments.
Further questions, Senator Scott.
Chairman, just wanted to serve note on the issue of these amendments. I've got one now drafted that will take care of the date problem and the subsection A problem. So when's appropriate, Mr. Chairman, I'm ready for that.
Thank you, Senator Scott. I knew either you or Senator Nethercott would be forthcoming, so we were depending on you. Further questions from Mr. Cox? Case.
Mr. Chairman, I think it would be just easiest to change the date on page 2, line 2 to December 31st, 2021, and do the same thing on line 9. I think that fixes all the date problems. I think people are seeing kind of boogeymans there, but I think that would clear it up real easy.
Thanks, Senator Case. I think we'll do that when we go to work on the bill, which will be shortly. So we'll take it in stride, and I'm sure it's coming. So further questions for Mr. Cox? Okay, thank you. I've bounced him a couple times. We have Representative Roscoe that's coming in from another committee, and I missed him once before. Welcome, Representative Roscoe. The floor is yours.
Thank you, Mr. Chairman, and I'm sorry I was a little bit late, and I think I've missed, you've moved on a bit already, but I'll just ramble on a little bit about how I see this this bill is actually, I can't see any way. I'm struggling with trying to see how it would possibly help the citizens of Wyoming, and why we would want to put it in front of the Public Service Commission at this point. It's confusing to me, and this has been defeated a few times before in this legislature. And the idea, I think the idea behind home generation is actually really working for Wyoming. And the idea is that it saves folks who invest in their own property to use less electricity that's provided by the utilities, which is what they do. And so my utility actually encourages, conservation of energy and electricity, and they provide incentives, financial incentives, to insulate your house better and use low light bulbs and buy efficient appliances. And Wyoming itself used to give out grants and low interest loans for these home generating places, if it's solar, wind, or geothermal. And I got one for my ranch down in Sublette County, and it's been working great. And even this year, the USDA Rural Development has incentivized rooftop solar and home generation for these rural communities. So it seems a little schizophrenic to have all this effort to reduce people's electric bills, and then have a bill like this that's threatening to kill this industry that's providing that. So also home generation, I think I'm a little out of step here, but home generation actually can help utilities by lowering their peak loads and the demand for new generation capacity. And this bill would just take us backwards. So really, I don't see the reason for it. And putting this bill in front of the PFC now, which I just got done talking to about having their workload being increased, and they're having to add more funding to their model. It just, it doesn't seem necessary at all. So that's about it. I guess if the idea of a subsidy is the fact that home generation is not being used, is not using or not paying for the infrastructure that's there. In the history of the United States, there's been all sorts of examples of building dams and rural electrification that's really been for public benefit, that did help grow the agricultural business in Wyoming and keep our rates really low. So it just seems like this bill would be taking us backwards, and I think we should get rid of it. So thank you very much for having me, Mr. Chairman. I appreciate that, and committee. Thank you.
Thank you, Representative Roscoe. Any questions, Representative Roscoe? All right, thanks so much. Ms. Whalen, are you available?
I'm here.
Welcome. We don't have your picture, but we can hear you.
Okay, thank you, Chairman Driscoll, for this opportunity to address my legislature from Zoom. This is very exciting. I retired from teaching and got to participate last year down at the Capitol, and I'm really excited to be able to do this from my living room. I believe that that we need to say no to this bill, Senate File 16, as it's written. And I believe that because it seems to be very, very hard on rooftop solar and kind of loses hope for those people that are looking into rooftop solar for having the incentive to go forward with it. I was kind of disappointed that only 14% of Wyoming people have solar in their homes, because this is really something that we should be taking advantage of here in Wyoming. We have more sun, we're in the top 8 states for sunshine, and we have these really cold winters, and all of us that sit in our hot pickup trucks know in the winter that solar works. So middle-class people, you know, we're not out building new homes. We have to look to save energy on the way we can. And rooftop solar these days is a way that we can start doing something that's going to lower our utility bills and help the environment at the same time. And I believe that when a family makes the choice to do solar, they are making the choice to get the whole family involved in conservation. So this encouraging people to be their own producers of electricity is something that we need to make ourselves a little bit more modern and appealing to people from other places who are looking to come to Wyoming. I did a little research, and what I'm hearing is that Wyoming hasn't studied this like maybe they should, but I noticed that Utah has net metering, Idaho, Montana, Colorado, and they give families credits for the extra energy, and then those credits reduce their price. So I kind of wondered why people keep trying to bring this bill up in Wyoming, because I know last year I participated a little bit in trying to get this bill stopped. So I kind of wonder, why don't we look at those other states? If they're doing net metering, why is it wrong for Wyoming? And then I also was looking at some real estate information. And according to Zillow, solar panels and rooftop, it reduces monthly bills for everybody. And we know people in Wyoming are hurting right now. And even in a good economic year, people hurt in the winter when they have to pay their utility bills. And it keeps some people from moving here because they hear about how high those are. Okay. It also, having solar increases your home value. So when people are investing in solar panels on their roof, they're also investing in their future, because most people like me, that home is your retirement. So you want to put money into it so it will sell. And when people come here from other places, they're looking for things like that. They're looking around the town. They're noticing the solar panels and the way that our state treats people who want to do clean energy. I heard a little bit about we don't want to subsidize these regular citizens who are putting this stuff out of their own pocket. They're putting this into their homes and their environment, and then they're producing a little electricity to help everybody else. I think that we could help them out a little bit. We are certainly helping out carbon industries that we should be helping to ease them out a little bit, because as we go forward, companies look, does your state invest in alternative energies industry? And if it does, we'll move there. If it doesn't, we'll go somewhere else.
Thank you, Ms. Webb.
Okay, and thank you. And I was a little nervous, but thank you very much. And I believe this is a great, great thing that you've done to put this on Zoom.
Good job. Thank you very much. Any questions for Ms. Whalen? Thank you very much for the testimony from the heart. Ms. Carano, I probably did your name bad, but welcome.
Thank you, Mr. Chairman, and you did quite well. I'm Ellen Carano. I'm here representing the Laramie-Albany County Environmental Advisory Committee, or EAC, and we oppose the proposed bill. We echo the points raised earlier by Mayor Weaver about the effect of net metering on our local governments, and due to Mayor Weaver's testimony, I will be quite brief. But 3 points about how net metering and rooftop solar are so important for the city of Laramie and Albany County to become more resilient, to provide long-term cost savings, and to support local job growth. So first, as Mayor Weaver mentioned, rooftop solar is becoming a really important part of the city of Laramie's municipal energy plan. We currently have 2 systems being installed on municipal buildings thanks to a Rocky Mountain Power Blue Sky grant. Future installations are planned and they'll require the financial backing of the city, which is much more likely if we have net metering and we have an expanded cap. Second, our committee has become quite excited about opportunities provided by net metering to return brownfield land to tax rolls through renewable energy projects. rehabilitated brownfields with solar power become bright fields, and property values adjacent to these sites will also increase, providing additional tax revenues. And then last, as many folks have brought up today, are the employment opportunities. So in addition to those great jobs in rooftop solar, major corporations, people like Amazon, Facebook, and Walmart, are committed to utilizing renewable energy. And during the last legislative session, Wyoming became the first state to pass laws aimed at encouraging development of the blockchain industry. The potential for net metering systems provides an incentive for these companies to relocate to Wyoming. Thank you for listening. Thank you for hearing the public, and thank you for your service.
Muted, Mr. Chairman.
Okay, thank you. Thank you, Mr. Carano. Any questions from the committee? Thank you. Mr. Zine? Hope I didn't butcher your name. These are all tough. And we have no hands up out in the participation crowd. If anyone wants to testify, if you get your hand up, we'll get you into the room. Go ahead, Mr. Zine.
Thank you, Mr. Chair. My name is Johnny Zine. I'm representing local governments here in the western part of the state for the town of Jackson, and also representing the Teton County government as well. I'm the Assistant Public Works Director for the town of Jackson. I want to come out and say that we are against and opposed to Senate File 16. We have been very proactive in terms of our investment into solar projects, and these projects have a very big effect on our constituents, saving our constituents money. We have solar systems at our wastewater treatment plant, on our water systems, town hall, courthouse. We have over 10 systems that we employ to offset and save money for our constituents. Of those 10 systems, we have generated about 7 million kilowatt hours, which, to put into perspective, takes about almost 12 million miles of driving off of the road. Huge benefit for us. We feel that Wyoming should focus on supporting one of our nation's fastest growing industries and not disabling it. Legislative policy should encourage customer savings of the residents of our state. Rooftop solar produces sales tax income for the counties in which the projects happen and for the state. Further, California and Maine and Nevada have done a lot of solar cost benefit studies that show that non-participants actually benefit from net metering of solar customers. The benefits are even greater when one considers the quantifiable societal benefits of net meter distribution generation, including the enhanced reliability and resiliency of those electric systems, land use benefits, air quality benefits, and local economic benefits. Further, locally, by producing more of our power locally, it actually saves our constituents even more money, because our local utility provider doesn't have to actually go out and purchase more expensive tier 2 or above power for our community as our community grows. Lastly, Mr. Chair, I would also like to say, if we are really looking at subsidies, and that the Public Utility Commission is going to look at subsidies, then let's look at all subsidies. And I'll give you a few examples. Multifamily residents subsidize single family residents. An apartment building is served by a single transformer bank, and the utility never sees the individual demand of those individual units, only the consolidated demands of the group. Further, customers served with cheaper overhead service subsidize customers served with more expensive underground service, who actually receive more reliable service during storm outages. Urban customers subsidize suburban and rural customers. There are typically 500 customers per circuit mile that are urban, 100 suburban, and 10 rural. So I think if we were going to really look at subsidies, why would we just focus on net metering and not focus on other subsidies as they are presented in the outdated rate system that everyone's talked about? I also want to agree with Mayor Weaver. This is a big benefit to our community. And again, I can't emphasize enough the economy that it creates and the money that it saves for our constituents in our community. Thank you, Mr. Chair, and thank you to members of the committee.
Muted, Mr. Chairman.
Thank you. I managed to stay on mute. Thank you for the testimony. Any questions from the committee? Thank you. We are out of people in the waiting room. If there's anyone in the waiting room that would like to testify, considering the number of emails we've had, we'll do it real quick. If not, we're going to close down public testimony. So, President Dockstetter, do you have comments while you're on? Apparently not. Okay, we're going to go ahead and close public testimony and go back to the bill. Committee, what is your pleasure? Senator Scott.
Mr. Chairman, I move the bill.
Okay, the bill's been moved. We're on the bill now. Senator Boner seconded it. Senator Scott.
Mr. Chairman, I've got two amendments. The second one will deal with the safety issue. What I want to do is deal with the subsection A and deal with the related date issues. So, Mr. Chairman, I move we delete all of subsection A, which is on page 1. You get rid of lines 13 through 15, and on page 2, it's deleting lines 1 and 2. On page 2, line 4, you delete the B in the parentheses and insert A. On page 2, line 9, you delete the 2021 and insert 2022. So this would apply to systems that come in July 1st, after July 1st, 2022. On page 2, line 12, the Public Service Commission deadline for getting their work done. I would move we delete January and insert April, so it's April 1st, 2022. And then on page 2, line 17, just conforming the numbering, you delete the C in the parentheses and insert B. Mr. Chairman, that's my motion.
Been seconded by Senator Nethercott. Discussion on the motion.
Mr. Chairman.
Senator Scott.
Mr. Chairman, I think A is frankly unnecessary. I thought about saying, well, the existing law will govern until we get this done. I think that'll be the case anyhow after the testimony we heard from the Public Service Commission. I think A is just best gotten rid of. That deals with the date up there. And then we have a system. Give the Public Service Commission until next April to get the new system running. I think the January 1st is just a little too tight, Mr. Chairman, to be fully practical. And then the switchover date then changes to July 1st, 2022. That I think deals with some of the issues of certainty in that interval. And I thought the testimony we heard before was right on point on some of that, so that the new system doesn't kick in until 3 months after it has to have been promulgated. I think, Mr. Chairman, that solves the date problems and we could move forward.
Perfect. Further discussion on the amendment. Senator Case.
Mr. Chairman, I do appreciate the work here. I think this is a workable compromise. I might suggest I agree with the good senator about it actually cleans the bill up to get rid of A. There's no need to have A. That just made it was just clear that there was a grandfathering, and we do all agree on a grandfathering. But Mr. Chairman and Senator Scott, how about if we, what would you think to changing the operational date to the end of this year? That would be 6 months of extension. You know, so that on line 9, it would say December 31st of 2021 and hold the commission to the existing date. You know, that it is a hard task perhaps for the commission to do, but this is an important issue. And I think the commission has plenty of notice. That gives them 6 full months to get it done. I can't imagine they couldn't do it in that time. They've done more and less.
Thank you, Senator. Is that a friendly amendment, Senator Scott?
Mr. Chairman, I would prefer not to go that route. I think given the amount of public interest that there is in this topic, it's going to take the commission a little extra time to hear all the testimony and complete their work. And I think if you make the 2 dates the same, then you have a period where people can't contract for any installations because they don't know what the rules are going to be once it's installed. I think it's better to have a gap there. And I think the April 1st to July 1st gap that I'm proposing would be adequate time. So, Mr. Chairman, I'll vote for the final amendment either way, but if he wants to propose that as an amendment to the amendment, fine, let's go ahead and vote on
I think we have our answer. Senator Case.
Mr. Chairman, I'm not going to muck it up like that. So I appreciate the good work. You know, it's a fair compromise. I'll support Senator Scott's amendment.
Well done. Any further amendments, committee? Well, I guess we got to vote on the amendment on the table. Excuse me. Any further discussion on the amendment on the table? Okay, that being said, all in favor, please raise your hand. Trying to get mine there. Believe that's unanimous. Thank you. Great amendment, Senator Scott. Any further amendments? Any further amendments? We're back on the bill. Any further discussion on the bill?
Mr. Chairman, Mr. Chairman, Mr. Chairman. Mr. Chairman, I forgot to unmute. Further amendment on page 2, line 13 after 2022 period, delete the balance of the line, delete lines 14 and 15. This gets that safety issue out of the bill. That's a red herring in this bill. It's implementation date on a previously passed piece of safety legislation. Let the existing law handle that. We don't need to get into that in this bill. So, Mr. Chairman, that's my amendment, is to delete those.
Senator Case.
Mr. Chairman, I think I agree with that as well. I think that safety requirement came in at the suggestion of the industrial consumers that testified at our last meeting. I just want to be sure to clear in everybody's mind that the safety requirements do exist. And I think it is. I mean, the problem is that these systems may produce energy when the rest of the electric utility is down. And that's a danger to our people that are working on these, the power lines. So that's why there's fairly elaborate safety requirements. And I don't think any of us wants to get rid of them, or all we were doing with this language as suggested was to make sure that safety applies. And I think it does under the metering statute. So I think Senator Scott's done some good work here too.
Any further discussion on the amendment? Question being called. All in favor of the amendment, raise your hand. Unanimous again. Amendment is passed. We're back on the bill. Any further amendments or discussion?
Question on the bill.
Please call the roll.
Mr. Chairman, this is a roll call vote on Senate File 16. Senator Bonner.
Aye.
Senator Case,
Aye.
Senator Nethercott,
Aye.
Senator Scott,
Aye.
Chairman Driscoll.
Aye. Senator Case or Senator Scott, who would like to carry it?
I think Senator Scott's done a great job.
I tend to agree. He fixed the bill. Senator Scott, will give it to you on the floor. Thank you. We ready for another 5-minute break? I think we can get one more bill in before we're out of time, probably.
If we could have the 5 minutes.
What's that?
If we
Yeah.
could have the 5 minutes, Mr. Chairman.
It was 12:05. We'll come back in. Shut off your mics and your video, please. Thank you. Hello, everybody back on? Excuse me. Next will be Senate File 30, Pandemic Response Review Task Force. Once again, I'm going to ask committee for who I should have presenting this. Senator Case? I can't hear you.
Yeah, I don't really, there's a reason you can't hear me, Mr. Chairman. Mr. Chairman, I'm not really the best person to present the bill, I suppose, but I will tell you that early on in the corporation's interim work, there were folks that said, we need to do something now, get something in the special session about curtailing the power of the health officer and, just a lot of stuff like that. And there was, as you know, people were in turmoil. They still are in turmoil. This bill sort of evolved to be a look back. Let's look back and take a look. And did we do things right? Did we do things wrong? Did we overreach? Did we not go far enough? And so it's with that spirit, I think the committee generally supported it. There were modifications made about the makeup of the committee and how many and whatever. But I do think in our history in Wyoming, this is right up there with one of the most historic things on the planet, of course, but of course for us, and to have a formal look back at what happened and try to figure out if we were appropriate in responses and not, and what we could have done better, what we needed to do differently, whether we trod on those rights or whether we supported those rights, is a good thing. It's a healthy thing. And we all kind of talked about it and we decided we don't want to do this in the middle of this, that is inappropriate. We're going to stand with the governor and the health officer, and we're going to see this thing through with the people of Wyoming. And then we're going to take the time to look back. And so that's where the spirit of this is. It may be better to wait on this one in a way and not put it in the short session. I don't want anybody to think we're trying to curtail any powers right now or anything like that, because that was definitely not the spirit that it ended up being. Now, there were members on the committee that felt very strongly about this, and they continue to express themselves. And that's absolutely fine. This is Wyoming and this is America. So, but I'm not sure this one's ripe to put into the short session. We can think about it a little later, but I think we can go ahead and discuss it today. No worries at all.
I'll kick just a little on that. I do think it's timely. I did notice it intentionally. I think there's a cry for something to be looked at, and I think this actually is a good vehicle to take a good first look. So that's where I was at.
Mr. Chairman, you're the chairman. Go ahead.
Senator Scott.
Yeah, Mr. Chairman, I want to second some of the things Senator Case just said. I think everybody's in agreement that when this pandemic is all over, we ought to take a good hard look back at what we did and see what we can learn from it. I would add a caution that in doing that, remember the next pandemic, which is what we'll be talking about, how the law is dealing with that, is going to be different from this one. You'll never get two that are the same, I think. So I think the question really with this bill is how do we go about doing that? Last year, when I was chairman of Committee 10 in the Senate, we had planned as part of our interim work to take a look at this sort of thing. And clearly, as Senator Case just articulated, the timing was not right in the middle of things. So we did not proceed on that. I think we're much better off rather than creating a new task force, which I think is a cumbersome way of doing things and we've created too many of these, frankly. Mr. Chairman, we're going more and more towards a full-time legislature, which I think is a terrible mistake. I think this ought to be part of the interim work of either this committee or the Labor Committee or some combination of the two, rather than a task force with the executive I think we're much better hearing from the executive and making our own legislative judgments. So, Mr. Chairman, I would hope we would not proceed forward with this bill.
Well stated. Any further comments to committee? I would accept a motion to table. Senator Case, would you like to make it?
Yeah, Mr. Chairman, I like this bill actually, so I would probably go the other way. I'm not going to
lay it back. Would you
Yeah.
like to lay it back? I'll accept.
Let's lay it back till the regular session, or
Okay.
till I don't know what that means. I'm so sorry, but not lay it back at the chairman's pleasure later in the session.
Consider it done. I don't think I have to take a vote on that. We'll just lay it back. We'll move on to the next bill and we'll leave this one at the bottom of the pile for the time being.
Thank you, Mr. Chairman.
Appreciate your input from both you and Senator Scott. The next bill is a book that we have down. I don't know if we can get through it. I'm going to ask, we've only got 20 minutes left, and the next one I noticed was Uniform Law Notarial Acts. Can we even take a swing at that in this time frame? Senator Nethercott.
Thank you, Mr. Chairman. I do think we can take a swing at it. And the primary reason for that is because of the amount of significant work that went into the bill before it even came to the committee. So the bill really was brought forth to the committee through the Secretary of State's office, who spent significant time and effort studying the issue, recognized the need for Wyoming to update its notary laws, and spent significant time working with the stakeholders, all of those industries that rely on notaries heavily. And the bill has been worked pretty extensively by the committee as well in the interim. So even though it's a big bill, it's been worked pretty well.
Would you like to take a quick run at it then? I would really like to get some of these out of the way.
100%. I'll take a run at it, Mr. Chairman.
God.
So committee, what you see in front of you is Senate File 29, which is the revised Uniform Law and Notarial Acts. As we all know, with this pandemic this last year, there's been a need to modernize some of our practices, particularly as it relates to business transactions. And one of those has to do with the ability to do remote notarizations or remote online notarizations, otherwise referred to kind of as RONA. It was on the Secretary of State's agenda to get to probably within the next legislative session, but as a result of the pandemic, obviously really made it a top priority in order to update our laws and to allow for these types of services to continue in a remote type of a session. So it is a uniform act, as you can see in the title. And so much of the bill originally presented to us by the Secretary of State's office came forth through a uniform notarial act law. We did revise it heavily. The committee did, just to kind of roll back some of what we thought maybe was too much regulation and too much emphasis on the importance of a notary. And so we'll walk through some of those pieces. So the definitions is pretty important as we work through the bill. Acknowledgement of the purpose of a notary, if you step back, is to ensure that the person who is standing before the notary is who they say they are. And that's it. The notary doesn't, verify the veracity of the document or anything associated with the document to be notarized. It really is that the notary has properly identified the person standing before them as who they actually are through some form of identification. So acknowledgement means a declaration by a principal before a notarial officer that the principal has knowingly and willfully signed a record for the purposes stated in the record. And if the record is signed in a representative capacity, that the principal signed the record with proper authority, signed it as the act of the principal or entity identified in the record, and acknowledges that the record was executed and acknowledged knowingly and willingly. So that the person standing in front of them actually has the capacity probably to sign it without really going as far as to say capacity, but they're certainly capable of acknowledging something with consciousness. We move down to page 2. Affirmation means a notarial act or part thereof, which is legally equivalent to an oath in which a person at a single time and place is identified by the notarial officer through satisfactory evidence. So again, it doesn't require a driver's license or any other specific form of ID. So if the notary knows the person just by, for example, I have notaries in my office, My notaries obviously know who I am, and I don't need to show them an ID every time my signature needs notarized. They just know who I am. So that's actually a pretty broad definition, and satisfactory evidence to whom is certainly a great question, but it seems to work for us to transact business in this country. Makes a vow of truthfulness or fidelity on penalty of perjury based on personal honor and without invoking a deity or using any form of the word swear. So kind of an unusual provision there, no doubt coming in from the uniform piece, but makes the purpose of someone signing that document doing so with a bit more of commitment that who they're saying to be is actually accurate. So here's what's important. In the next section, we're on line 12 now. Appearing before, in the presence of, personal appearance and personally appear mean being in the same physical location as another person and close enough to see, hear, communicate with, and exchange identification credentials. And so on line 17 is really the onus of the bill, kind of right here, with that person or interacting with another remotely located person by means of an electronic notarization or other form of communication technology in compliance with this act. So, you know, what's important is how traditionally we have done it. You can't sign a document and then go to a notary and have it notarized. That actually would be improper. You're supposed to sign the document in front of the notary at the time, kind of simultaneously. So physically, you need to be together. This obviously obviates that and allows for you to appear physically together, but remotely, like what we are doing now through Zoom. So this is really kind of the key part of the bill there, page 3, line 17. Going through is kind of the types of technology associated with how that remote appearance can occur. And so there's pretty specifics associated with the type of technology, that the electronic device, to ensure, again, that the integrity associated with the concepts around remote notarization still exist. Again, that requirement of simultaneously is there if we look at line 7 on page 4. So again, you can't sign it in advance and have the notary sign it later. It really needs to occur at the same time, and that can happen remotely. Here's some of that technical compliance required on line 14 regarding credential analysis. Means a process or service through which a third person affirms the validity of a government issued identification credential through a review of public and proprietary data sources. So interesting language there associated with the type of technology that can really allow for the simultaneous observation of a signature. Credible witness, pretty standard language there. Page 5, line 2, dynamic knowledge-based authentication assessment means an identity assessment that is based on a set of questions formulated from a public or private data sources that does not contain a question for which the principal provided a prior answer to the entity doing the assessment. So what this means, and I'm remembering from testimony, it's like when you access your bank account online and they require you to do maybe a 2-factor authentication or some other security type question to ensure that you are who you say you are. And that's through the use of technology. Electronic notarization system, moving down the page, again, goes through those technical requirements associated with the ability to remote notarize. An electronic record, right? So oftentimes, you know, I bought and sold a house and I never touched a single piece of paper, and it was all done remotely. I was in one location in the country, my husband was in another location in the country, but we still created an electronic record that had the same force and effect of had we signed physical paper. Electronic signature, right? I actually didn't physically sign it. It wasn't my signature. It was an electronic signature. Here's it defined in statute. So pretty common concepts that we're already practicing and doing in day-to-day business. Page 6, line 15, identification credential. So this would be, you know, a government issued identification that can be used as a way to represent who you say you are. Moving down, identity proofing means a process of service if required by an electronic notarization system or other form of communication technology by which a third person provides a notarial officer with the means to verify the identity of a remotely located person. So using that technology as a basis to confirm that someone is who they say they are. Interesting here to see on line 8 onto the next page, biometric data. So an eye scan, a fingerprint scan, all of those kind of concepts. If someone chooses to use that type of technology, they can. Moving through, notarial officer, all of that is consistent with our laws associated with current notaries that the Secretary of State's office currently credentials. Moving through, recognizing we're short on time here. Principal, that's the person who's getting their signature notarized. Remote ink authorization, unique on page 11, line 10, means the notarial act of an acknowledgement performed by means of an electronic notarization system or other form of communication technology on a tangible record that meets the standards adopted in this act. So just some concepts associated with once it's notarized, what we're calling it. Here's the definition of remote online notarization, line 16, page 11. Pretty self-explanatory. Definitions of satisfactory evidence, lines 2 on page 12, all the way through the remainder of the page.
Mr. Chairman, Senator Scott's been trying to get your attention.
I am sorry, I'm trying to follow the bill. Senator Scott.
Mr. Chairman, we're time short. I move the bill.
Very good. We are there.
We love her presentation, though. We really do.
Thank you. Thank you, Senator Scott. I am very grateful.
That's exactly how I present bills. I always thought I short-circuited things a little, so bill has been moved and seconded. I suppose I should let the Secretary of State's office have a swing if they would like, real quick.
I did see Senator Scott going like this, and I'm like, okay, I'm going faster. I'm going faster.
Okay, we've got Secretary of State in now. I see Miss Wheeler there. Looks like I can't see real good.
Oh, Ms. James.
Now, Miss James, excuse me.
Yes. Mr. Chairman, can you hear me?
We can. Thank you.
Wonderful. Thank you. Kelly James, Compliance Division Director, Wyoming Secretary of State's Office. I have with me also our Notary Officer, Carissa Corsi, and we will be quick. Thank you for all your work on this committee, and thank you to Senator Nethercott for walking us through it quickly. And I do just have 3 very small technical fixes that we just need to look at real quickly if we can.
Perfect. I thought you might have something of the sort in a 60-page bill.
Perfect. So, Mr. Chairman, on page 9, line 15, this came from the Uniform Commissioner's Office, since this is a Uniform Act. They're requesting, and we agree, that after official stamp, we would insert or in quotes seal. So it would be or seal. And that is because the notary does refer to their stamp or seal in both ways. And so we just want to make sure that that includes that. On page 49, line 5, this is regarding the audio-visual recordings and journal security. This was part of the Uniform Act, and it was amended at the last meeting that the journal would still be required and would be recordings, but the retention was removed. And so we would just ask that you strike the words "and retention" on line 5. And then our final amendment that we have that we found is on page 73. And this is lines 4 and 5. And I'll give you just a second to get there. This is a conforming language on different statutes, and this is under Title IX, the duties of the Secretary of State. And we did find that, first of all, line 5, it says $50. It actually should be $60. So that was incorrect. It should be $60 there. That is the new fee for the Notary Public Commission. And above it, it talks about a notarial officer. We don't commission notarial officers. We only commission notaries public. So we would ask that it says issuing a notary public commission and then $60. So those are our 3 small technical fixes we have, and we sure appreciate the committee's support. Thank you. I'll stand for questions.
I would move it at the appropriate time.
Question.
You're muted, Mr. Chairman.
Senator Scott, thank you. Do we have a motion on the amendments?
I move it at the appropriate time. If this is it, it's moved.
This is it. The bill is in. Any discussion on the amendments? All in favor, raise your hand. Unanimously passed.
Does
Guess
anybody else want to testify on the bill? I don't think so. So I would move.
Hey,
question
Mr.
on the bill.
Chairman, Mr. Chairman.
Yes.
I'm sorry, I see Scott Meyer's hand up, and I can bring him in if that's your.
Hold it, please. I thank you very much, Senator Case. Don't want to shirk anybody. Mr. Meyer.
He's trying.
Very good. Welcome, Mr. Meyer.
Scott Meyer with the Wyoming Bankers Association. We stand in support of this bill, but there is just one item that we still struggle with a little bit, and I think that Senator Nethercott had probably alluded to it a little bit, but it's our position that when you have a notary in your office and you are notarizing, whether it's a bank office or whether it's ABC company or what have you, that that keeping a journal like this can just be a little bit redundant and time consuming. And in the era of people saying we just need to have less government regulation, we think that if you're just holding it out and you're doing stuff either for your own employees or in the case of maybe Senator Nethercott and myself, when you're having a law practice, your clients, to keep a journal like that just seems to be a little bit cumbersome. It certainly isn't like a deal killer, but it just seems to me that it's a waste of a lot of time and effort to keep journals on stuff that we're not like your local convenience store or grocery store that's notarizing documents for people that we don't know, and we know everybody that comes in and what we're doing with that. So I could see where maybe the idea behind the law is to make sure that you know who is there, but in our cases those things are not people that we don't know, and that we know everybody that we're dealing with. So I would just think that there ought to be a way to carve out in that statute that a journal is required when you don't know who you're dealing with. And that's all I have to say about that. I would stand for any questions.
Thank you. Questions? Senator Scott.
Question on the bill. I don't think we can deal with an amendment in concept at this point.
No, we can fix that. It'll come on the floor, Mr. Meyer. I can almost assure you someone will bring it. We have a question on the bill. Roll call.
Mr. Chairman, this is a roll call vote on Senate File 29. Senator Boner.
Aye.
Senator Case.
Aye.
Senator Nethercott.
Aye.
Senator Scott.
Aye.
Chairman Driscoll.
Aye.
That passes.
Bill is passed. Senator Nethercott, you'll get to finish the bill on the floor. You got the first third done. We'll let you do the other 2/3 on the floor. Any further comments from the committee of any kind?
Mr. Chairman, I want to congratulate you on making it to the plethora of corporations committee chairmen and chairwomen that have been around, and thank you very much. You did a good job.
Thank you, all of you. For someone that's been on a lot of committees through his career, no offense to the past committees I've served on, this is by far the most professional, smoothest committee I've served on since I've been in the legislature. I thank all of you. Rarely do you get to run a committee like this, and I thank you. It's been a pleasure. So till next time, thank all of you. Thanks particularly Mary Beth, Danielle, and all our staff. Pretty smooth for a virtual meeting. Thanks again.
Bye, everybody.